I call this Committee of Civil Law and Data Practices Policy back to order for our second part of the day. It's still March 31st, 2022. First up, House File 3254, Senator Pratt. Apologies for the schedule kerfuffle today. Senator Pratt, welcome to the committee.
Well, that's fine, Mr. Chair. Thank you for having me. Members, House File 3254, I like to say better known as Senate File 2991, the underlying bill was passed several years ago, back in 2014, by unanimous vote of both houses. The legislature amended termination status for Minnesota sales reps that were housed in Minnesota. That when they were terminated by their corporate partner, that they were governed by the laws of Minnesota. What we found since the law passed, Mr. Chair, is that companies are writing in that they will abide by Minnesota law, but they're making the venue in other states. And it becomes a burden on our sales reps to do that. So I want to thank my co-author, Senator Latz, to make a very simple change that not only will we follow the law in the state of Minnesota, but we will also have the venue in the state of Minnesota. We believe Minnesota law should be heard and decided on in Minnesota courts. Mr. Chair, that is effectively the bill, and I'm happy to stand for any questions.
Thank you, Senator Pratt. Any questions from committee members? All right, hearing none. Senator Limmer, if you'd move this bill to the floor.
He's here.
Oh, Senator Latz. Yes. Senator
I
Latz.
didn't see you back there, Senator Latz.
Senator Latz moves House File 32.
Wait, I wanted to move it.
There's plenty more to be able to move this evening. House File 3254, recommended to pass and move to general orders. Senator Latz motion. On that motion, all in favor say aye.
Aye.
Aye. Opposed, no. Motion prevails.
Thank you, Mr. Chair.
Thank you, Senator Pratt. Senate File 3501, Senator Draheim. Welcome to the committee.
Thank you, Chair. I think I'm lost. I don't think I've ever been to this committee before.
Well, you're in for a real treat then. When you're ready, go ahead, Senator Draheim.
Thank you, Chair Matthews and members. Back in 2020, Senator Kiffmeyer passed a bill that updated the practice for physician assistants. The new law is working well and help facilitate health systems hiring physician assistants who are greatly needed to address our healthcare workforce shortage. Last year, physician assistants in Minnesota provided over 10 million patient encounters. Most of our health systems couldn't function without physician assistants. This bill, members, modifies the Practice Act of how physician assistants are supervised, but didn't address the hundreds of cross-reference effects by this change. So Senator Kiffmeyer's bill, originally done in 2020, didn't reference all the different areas. That's why we have 150 pages here, members. So there's 168 corrections, technical fixes throughout the bill. And if you want me to read the pages, I sure can, Chair Matthews.
Senator Bigham.
Yeah, Mr. Chair, since this is Senator Draheim's first stop here, I really do think we should have you go through the bill, and every time physician's assistant is in there, you need to explain to us, like, what they now are gonna be able to do.
Senator Bigham, do you want to move to extend to 1 o'clock right now?
No, I'm kidding. It's a great bill, members. I really do think it modernizes the practice of, the advanced practice of physician's assistants, and I hope folks can support it. I know we might have another testifier, but that's what I'll say.
Senator Draheim, I believe you also have an A5 amendment.
I do, I was gonna ask if we could move the A5. That is a fix from the House. It was heard in the House and passed, and that was a fix to the fix.
I can move the A5 amendment, Mr. Chair.
Senator Bigham moves the A5 amendment. Did you have any further discussion on the amendment, Senator Draheim?
No, Chair.
Any questions about the amendment? Seeing none, all those in favor say aye. Aye. Opposed, no. The A5 is adopted.
So, members.
Senator Draheim.
Thank you, Chair, and members. The Board of Medical Practice and the Board of Pharmacy have reviewed the bill and have not expressed any concerns. I have a letter here from the Minnesota Medical Association. When this was heard in HHS, Dr. Klein, Senator Klein, was in favor of the bill, spoke in favor of the bill, supported the bill, and defended the bill. We did have one testifier come up to me right before the hearing in HHS that did have a couple concerns, but Dr. Klein didn't feel they were warranted, and I tend to agree with him. But I do believe we do have a testifier if you want to take the testifier.
All right, thank you, Senator Draheim. I have Natasha Chernovsky.
I think Leslie wants to go first. There's a-
Okay, I don't have that name on my list. Could you identify who that is?
Leslie Clayton.
Leslie Clayton. There, you're online. I see you now. Ms. Clayton, welcome to the committee. If you would identify yourself for the record, and then feel free to begin.
Thank you, Mr. Chair. Thank you to the committee, and thank you, Senator Draheim. My name is Leslie Clayton. I am the legislative chair for the Minnesota Academy of PAs. I've been a practicing PA for 24 years, and I practice in family medicine. I represent over 3,500 PAs in the state of Minnesota who practice in all areas of medicine and in all specialties and in all settings. PAs have been a profession since the 1960s when we were developed through physician leadership to meet a healthcare shortage, which is not unlike what we are experiencing today. And PAs have risen to that occasion. We were pivotal in the COVID exchange. And the reason that we come before you today is to make sure that we are updating our bills and our practice capacities in correlation with modern healthcare. The changes that were made in 2020 addressed additional excessive paperwork regarding our regulatory processes. And what we're doing this year is just harmonizing the language from that 2020 bill to make sure that it's correlative with those regulatory changes that took place in 2020. We are not changing our scope of practice with this bill. We are simply updating terminology so that there is correlation with the 2020 Practice Acts. As Senator Draheim indicated, we have had this bill approved through the Board of Medical Practice, the Board of Pharmacy, the Minnesota Medical Association, the Nursing Association, and the APRN Coalition. There are no contentions with this bill regarding the stakeholders. You may hear testimony that there's concerns about the safety of physician assistants. We have volumes of data that indicate that when PAs participate in the care, we increase the quality measures, we reduce costs, and we increase access to care. Patients always have a choice in who they want to see for their healthcare provider, and many, many patients choose a PA. I am a primary care provider, and I have a very large following. I have patients that have followed me to 3 different practice locations within 3 different health systems in the state of Minnesota in the 17 years that I have practiced here. We are safe, we are high quality, and we expand access to care. PAs are already able to sign death certificates. We already authorize care plans and practice autonomously, and when necessary, we reach to our physician colleagues for assistance. We do provide screening for examinations such as DOT. We are authorized to prescribe opioids, including buprenorphine, and we are already mandated reporters within the state legal medical practice acts. And we engage with EMS services on a regular basis even being part of the EMS care team in certain settings. There are no concerns regarding practice scope changes with this bill, and we are simply correlating our language. We appreciate you hearing this, and we hope that you will support cleaning up language in external doctrines of medical practice. I'm happy to take any questions.
Thank you, Ms. Clayton. We'll do our testifiers and then open it up to questions at the end for all the testifiers and the author. So, Ms. Chernovsky, welcome to the committee. If you'd identify yourself for the record and then feel free to begin.
Thank you, Mr. Chair. Members of the committee, my name is Natasha Chernovsky, and I'm the Legislative and Policy Specialist for CCHF. And I'm here today to advocate for patient safety and share our concerns about how this bill does in fact expand scope of practice. As legislators expand scope of practice, healthcare corporations have begun to replace physicians with non-physicians. For example, less than a year ago, a hospital in Charlotte, North Carolina, replaced all their board-certified pediatricians and neonatologists with a team of nurse practitioners. Furthermore, the American Academy of Physician Assistants recently and officially rebranded physician assistants as physician associates and called for there to be no physician oversight for PA's practice. We believe that this bill specifically moves PAs much closer to independent practice with no physician oversight of patient care, especially since in line 118.29, it strikes physician supervision from the definition of a licensed PA. Patients already tell us that they often don't get to see physicians anymore when they go to their appointments. They are given non-physicians, such as physician assistants, for examination, diagnoses, and treatment. PAs have their place and are needed, but they are not medical doctors. The difference in training is simply too great. We've been told that SF 3501 does not expand PA's scope of practice, and Ms. Clayton just referenced that in her testimony, but simply clarifies the role of physician assistants for purpose of payment. This claim, however, underscores our belief that the bill does indeed expand scope of practice, because if this claim is true, insurance and government payers must not see the items authorized in the bill as being authorized within the PA's current scope of practice as written in section 147A. Thus, we oppose this bill. But if the committee intends to pass it, we request 2 amendments to provide patients with transparency and access to a doctor. Our suggested amendments are as follows. On line 30.15, after care, to insert a physician, advanced practice registered nurse, or physician assistant must verbally announce their title to a patient without the use of acronyms. And then secondly, on line 31.6, after disclose, insert a patient must be referred to a physician for assessment if their condition has not improved after 2 appointments with an advanced practice registered nurse or physician assistant. I'd be happy to answer any questions, but thank you so much for your time.
Thank you for your testimony. Is there any questions from committee members? Senator Limmer.
Thank you, Mr. Chair. I'm trying to figure out what is the connection with the Civil Law Committee with this bill? What is our jurisdiction?
I would, Chair and
Senator Draheim.
Senator Limmer, there's a lot of people asking that question. I don't see the civil law connection personally, but I'm not on your committee.
Why don't we
So-
ask counsel?
Sure, perfect.
Ms. Primo.
Mr. Chair and members, the bill makes several technical corrections, to several statutes within our jurisdiction. There is a bill summary in your packets that identifies just the civil law and data practices provisions. And generally, what this does is adds physician assistants to many of those statutes and puts them in line with some of the other health professionals. It has to do with immunity, a little bit of data, health records, but they are all in the member packets.
I think we will try to grab a few more copies of that summary. It may have gotten lost in the shuffle from the afternoon, so, thank you, Ms. Primo.
Mr. Chair, could you instruct the staff to bring one of these to the author of the bill?
Yes.
I have one,
Oh, you do?
Senator Limmer and Chair. I think, somewhere in the mountain of paper, I do have it. And,
Is there any more discussion from committee members?
Mr. Chair, I'd be ready to move if you are.
Are the members
Chair.
comfortable, or Senator Limmer?
Mr. Chair, Ms. Chernovsky recommended two amendments. The first amendment, giving notice to a patient of who that individual is. It happens to be a physician assistant. It states physician advanced practice registered nurse or physician assistant must verbally announce their title to a patient without the use of acronyms. Senator Draheim, do you have a reaction to that?
Senator Draheim.
thank you, Chair, and Senator Limmer. You know, my interactions with physician assistants is that they have announced who they are. When I've gone into the doctor's office, if it's a nurse practitioner, RN, whoever, they usually introduce themselves as they come into the room. I have not noticed if they use an RN or an acronym, or if they use their whole spelled out name of whatever position they hold.
Can I address that?
I think
on Zoom.
online testifier.
Ms. Clayton.
Yes, sir. I'd like to point out that we are not removing supervision from our Practice Act. That was done in 2020. So this is not a scope of practice change. And with regards to title, we do have title protection in the state of Minnesota to use the identifier PA. That is a legally recognized terminology for our profession. And every medical professional is instructed to present themselves in front of a patient. Even the lab technologists and the x-ray technicians and the nursing assistants are professionally expected to represent themselves. This does not need to be legislated. This is professional standard.
Mr. Chair.
Senator Bigham.
I would concur with both Senator Draheim and Ms. Clayton. If you go to a doctor, they typically say, I'm so-and-so, I'm so-and-so's nurse, Dr. So-and-so's nurse, or the PA, nurse. So I agree. I don't think it needs to be legislated. I mean, that's like, when I'm at my other job, I announce that I'm the paralegal and the attorney is the attorney. I mean, it's just practice in your area of expertise where you are. So I agree with Senator Draheim.
The suggestions also stated are under the jurisdiction of the HHS committee, not the jurisdictions of our civil law committee as well.
Oh, there's that.
So make sure members have note of that. Is there any more discussion on the bill? Senator Latz.
Where is the bill proposed to go from here?
To general orders.
But it did come from HHS.
Yeah.
Correct.
It's already been there.
So they had their opportunities there
Yeah.
to consider these kinds of issues.
Mr. Chairman.
Thank you, Mr. Chair.
Senator Limmer.
Mr. Chairman, I know we always, we try to follow the jurisdictional parameters of our committees. And I was just going to ask Ms. Chernovsky, is there a need to have title? We're hearing from the professionals that there's a industry standard that they do that anyway. What is the problem we're trying to solve?
Ms. Chernovsky.
Mr. Chair, Senator Limmer, we've heard from many of our constituents that when they go into a clinic, they may have scheduled their appointment under Dr. So-and-so, but then are received by the physician assistant. However, they were not informed that that was a PA until after they intentionally asked them or after the appointment. And so there have been instances when there just isn't that introduction, and this would safeguard against that in the future.
Okay.
I would also like to point out, these changes are taking place within the Patient Bill of Rights that's already calling for for provider identification to the patient. So it's simply clarifying that language so that this happens in statute as well as in practice.
Yeah, I think.
Senator Limmer.
Mr. Chair, I think I'm going to withdraw my suggestion here. Because in our committee, we have a fairly tight jurisdiction, even though we cover a lot of ground. But I think this is getting a little too prescriptive for our committee, so I'm sorry, I have to withdraw it. Thank you.
Any further discussion on the bill?
Mr. Chair,
Seeing none.
I would.
Senator Bigham.
Thank you. I'd move that Senate File 3501 as amended be recommended to pass and be sent to general orders.
On that motion, all in favor say aye.
Aye.
Aye, opposed no.
No,
The motion prevails. Thank you, Senator Draheim.
Thank you, Chair and members.
All right, next up, Senator Howe. Senate File 3193. Welcome to the committee, Senator Howe.
Thank you for hearing the bill, Senator Matthews. And Senate File 3193 is basically addresses mental health data that is disclosed to law enforcement folks. Law enforcement agencies across Minnesota and the country are being challenged by a growing number of calls for service involving people with mental health needs. And with law enforcement agencies are trying to contemplate best how to serve these residents, and they're trying to figure out exactly what the best way to do it. Some law enforcement agencies are considering embedding social service professionals, and other governmental jurisdictions are in partnership with other agencies when officers respond to calls for mental health services. Other law enforcement agencies are considering not having officers respond to these calls, but sending social service professionals to respond. Some agencies are doing both of those. While these social service professionals are able to gather helpful information for their work during these response calls, the current law limits them from sharing any of that data that would be helpful for law enforcement as they respond to other calls involving the same people. So what this tries to do is to allow some information that would help these law enforcement professionals de-escalate the situation. It would help them to possibly de-escalate the situation so they don't have to haul these folks to jail and they can get the service they need. So with that, Mr. Chair, I would offer the A2 amendment.
I can
Well, I
offer,
guess I can't offer it. I
I'll
would
off-
ask somebody to go to the,
I'll offer
offer
the-
the A2 amendment.
I'll offer the A2 amendment.
As a co-author, Senator Bigham offers the A2 author's amendment. All those in favor of the amendment say aye. Aye. Opposed, no. Amendment is adopted.
Thank you.
Senator Howe.
Thank you, Mr. Chair, and I would ask for maybe council to walk through the bill because it was a delete all amendment.
Ms. Primo.
Mr. Chair and members, so looking at the A2 amendment, Section 1 amends a section on mental health data and authorizes certain mental health entities and providers to provide data related to a patient or client who's going through a mental health crisis to law enforcement, as long as the law enforcement agency has the person's name and has responded to that mental health crisis. And turning to page 2 of the DE, it also makes some clarifying changes in current law. For example, it allows part of the data that's released to include strategies to address the mental health crisis. Section 2 makes very similar changes to the Minnesota Health Records Act, and similarly authorizes the release of mental health records to law enforcement in similar situations. And you'll notice at lines 3.8 to 3.18, it mirrors some of the current provisions that are in section 1. So, for example, the list is pretty similar to the list in chapter 13. And additionally, the requirement at lines 3.16 to 3.18 that the law enforcement agency notify or tell the patient that these records have been obtained is a similar requirement under chapter 13. Section 3 amends a provision that allows a county to establish a multidisciplinary adult protection team. So it adds to this team in current law, community corrections agencies and local enforcement agencies, and thereby under that statute, by operation of current law, it will allow for some additional information sharing with those agencies as long as they're part of this multidisciplinary team.
Thank you, Ms. Primo. Anything more, Senator Howe?
I think there's, we've worked on this for a number of years, and I think we've finally gotten to a point where just about everybody's on board, but I think we should go to testifiers now.
All right, sounds good. We have a number of testifiers on the list for this bill. We also have a number on a bill yet to come up, so if the testifiers could be succinct, that would be appreciated. I'll take it in the order I have here. We'll do Rich Newmeister first and Irene Gow after that. Welcome back to the committee, Mr. Newmeister.
Chair Matthews, members of the committee, good evening. My name is Rich Newmeister. The language that's being on lines 2.1 through 2.11 and 3.8 through 3.18 has been around since 2004. This is the first time where police are able to get mental health information. I, along with Sue Abderholden, Don Gemberling, who is well-known in the privacy circles, and a bunch of people, came up with that. At that time, and even continuing until recently, only they were using this law to get more information about people in situations that Senator Howe described. Now, because of the resources, the public attention on it, and because of more situations where people have been literally killed or situations, or tragedies, this proposal is here. As was introduced, it was very broad and raised a lot of concerns for myself. But the League of Minnesota Cities did some research and said, hey, we have some current law dealing with this, let's focus on that. So what you have done is used old law, changed it a little bit, with some definitions. Issues, I think, are again, some questionable. What is the information actually going to be released? That's one. Number two, the amendment, what it does on lines 316 through 318, they put in the right to be notified when you get the information from the private provider, because that right is like that with when you get it from the state or government agency. So why not make sure that people are notified? Secondly, in my discussions with Senator Howe and the League of Minnesota Cities representative, the other concern I had that a lot of these agencies now are going to start doing this. There's more robust asking for this. Some agencies do have policies, some do not. By speaking with Senator Howe, and he might want to share some insight on that, in the next stop, they're going to put language in there or something similar that says law enforcement agencies must have policies, procedures, and rules how to handle the information, how to make sure it's secure, and those those kinds of things when it's held within the agency. So, Mr. Chair Matthews and members of the committee, that is my 2 cents. And I apologize if I wore my hat earlier when I testified on another bill. I had to make sure I don't wear it today when I testify. Thank you.
Thank you, Mr. Newmeister. Next up, Ms. Gow, welcome to the committee, and following her will be Jody Gherkin from Centricare. Ms. Gow, welcome to the committee.
Mr. Chair, members, my name is Irene Gow, and I'm with the League of Minnesota Cities. Thank you so much for having this hearing today. I want to start by thanking Senator Howe and Senator Bigham for all of their work on this important issue, and for you having this hearing tonight. I know it's a long one, so I will keep my comments brief. There'll be other testifiers who will talk more about the impacts of the increasing number of mental health calls and what it means for them for their day-to-day work. What I wanted to focus on is the delicate balance that this bill we have strived to achieve in terms of ensuring that law enforcement has the data that they need for these mental health calls with the importance of privacy. That's why the work that you have before you, as Mr. Newmeister had mentioned, is narrow in scope. We worked very hard on that. It was the work of a variety of stakeholders and input from folks like cities, as well as NAMI, private providers like Centricare, county human services, community corrections, county attorneys, and law enforcement. We also made sure to seek input from other folks who would have interest in privacy or openness, including MNCOGI, ACLU, Newspaper Association, and Mr. Newmeister. The information that is going to be shared under this bill is limited in scope. What you would get under this bill is if you were at a mental health call, you would have to provide the information that Ms. Primo had identified, and the only information you would get would be the name and phone number of a therapist, a caseworker, or someone who would be similar, and the strategies to address the mental health crisis. That is it. We're not looking for information. We're not looking for a patient file. We're not looking for what you would traditionally think of as a health record. And it's through the input of these different stakeholders, again, including mental health providers, that this limited information will aid when in addressing the increasing number of mental health calls. And while Sue Eberholden is unable to be here tonight, NAMI is in support of the bill, and she was okay with me sharing that information with you all. So that's why we're here to ask support for this bill. There are some additional comments in your packets. There's a letter from the League that flushes out the rest of the bill so that you can understand why we came to the language that you have in front of you tonight. And with that, I'm happy to take any questions later if there are any.
Thank you. Next up, Jody Gherkin, and following will be Dave Bentrud from the Waite Park Police. You in person or online?
I'm online.
I believe. Welcome to the committee. If you would identify yourself for the record and then please begin.
Sure. Thank you, Mr. Chair and committee members. My name is Jody Gherkin. I am the Director of State Government and Community Relations for Centricare. I'm here this evening in support of Senate File 3193, which would enhance the ability of local jurisdictions to exchange critically important mental health information to coordinate services during a mental health crisis. Centricare has a long, successful relationship with our law enforcement agencies and have collaborated on many innovative initiatives to best serve the greater St. Cloud area. We are consistently evaluating opportunities to meet the needs of our patients and our communities. At Centricare, it is our goal to provide the right care at the right time at the right location. Therefore, we are committed to working with our community partners in efforts such as these to extend that continuum of care outside of our hospital and clinic settings. The intent of this bill would allow organizations to share important, possibly life-saving information during a mental health crisis. This will help local jurisdictions better respond and support community members who are in volatile situations. We take the confidentiality and privacy of our clients very seriously, but we are also acutely aware that mental health issues have escalated exponentially in the past few years. This bill has been well thought out to ensure that, again, only a minimal amount of information be shared, and in doing so to help best assure the best possible outcomes. Sadly, there are too many incidents where the outcomes were grave, and that could have been different if there was the opportunity to share critical mental health information. It's important to note that many stakeholders representing numerous disciplines have come together to provide input into the language of this bill. We applaud Senators Howe and Bigham for listening to the needs of their communities and authoring this important legislation. Thank you for the opportunity to testify today, and I just ask for your support of Senate File 3193. Thank you.
Thank you, Ms. Gherkin. So we will take Officer Ruud next, and then Nikki Niles will follow him. So Officer Ruud, welcome to the committee.
Excuse me, Chief Matthews, members of the committee, thank you very much. My name is Dave Bentrud. I'm police chief for the city of Wade Park in Stearns County. And I also want to thank Senators Howe and Bigham for their support on this. Just for some context, the Minnesota Chiefs, Minnesota Sheriffs, League of Minnesota Cities, NAMI, and others have been working on a mental health responses best practice guide that we hope will be used as a resource across the state to help communities and police agencies in their response. But in that work, we've identified some challenges that I think we need to try to address and overcome. And I want to try to be as real world here as I can as I share, but I've been a member of the board of the Minnesota Chiefs of Police now for 11 years. And my very first work group that I was a part of in that role had to do with mental health, crisis response, and law enforcement's role in that response. And so I really appreciate the opportunity to talk with you tonight. But and while I applaud any efforts that we can make to determine some alternate response options, it is my view, my opinion, that police officers, our sheriff's deputies, will continue to respond to a vast majority of the mental health crisis calls that come in. And I want to say too that, and forgive me for not getting the first testifier's name, but I think what was being referred to there is a provision in statute that talks about emergency information that can be shared with law enforcement. And unfortunately, the way that's been interpreted is a more egregious situational where somebody maybe is barricaded or has hostages, those types of things. It does not really open up the lines of communication for those individuals that are having a frequent contact with law enforcement. And law enforcement certainly isn't the only barometer for escalating behavior, but we're probably one of the key ones because we have interactions with individuals. We see the escalating behavior before it gets to that crisis stage. And so when it comes to trying to address those issues and to prevent bad things from happening, we are oftentimes kept at arm's length when it comes to our ability to learn or share information that might help us. In Stearns County, we work in part of a multidisciplinary team. That's our concept. And our focus really is on high utilizers of services, both mental health and police. We really wanted to take pressure off our emergency rooms. We wanted to reduce the number of individuals incarcerated for relatively minor crimes, quite frankly, when the real issue is their mental health issues. So, so again, in doing this work, we found some statutory language, or at least the interpretation of those statutes that really have kept law enforcement, again, at that kind of that arm's length. And as the primary responder to these crisis calls, I think that kind of puts us, in my opinion, in a unfair advantage. Or a disadvantage. And so the ability to share some minimal level of information in this multidisciplinary team environment is critical. So, you know, and the other reality is too, is that law enforcement, you know, we see the behaviors, we document the behaviors, we certainly don't diagnose, but having the ability to coordinate with counselors, social workers, other advocates prior to, during, or after a critical call or a mental health type call is really important, I think, in helping that individual deal with whatever the issues might be. And conversely, our ability to share some basic information with a counselor can really help them better coordinate the care that their clients might need. So again, I really appreciate the opportunity to share some of our experiences, and I'd really appreciate your support for Senate File 3193. Thank you.
Thank you, Chief Bent Ruud. Appreciate your comments. Next will be Nikki Niles, who I believe you are remote as well, and then Commissioner Terrell Clark.
Thank you.
Let's see. Welcome to the committee. If you'd identify yourself for the record and then please begin.
Thank you. Good evening, Mr. Chair. My name is Nikki Niles, and I'm the Director of DFO Dodge Fillmore Olmstead County Community Corrections. Thank you for this opportunity to testify on behalf of AMC and Micah this evening in support of Senate File 3193. In Olmstead County, we've implemented a multidisciplinary team consisting of social workers within the Community Corrections Department. They work in partnership with both Rochester Police Department and the Olmstead County Sheriff's Office. This team works together to respond to calls for emergency and non-emergency services that address public health concerns such as mental health, chemical health, substance use, and well-being. This program has been working well, not introducing clients to the criminal justice system and or getting clients out of the criminal justice system exclusively based off of public health concerns. But we're finding that some of the data sharing laws are too limiting to offer the needed assistance to the people we serve. Members of this community outreach team need the ability to talk to one another and other community partners, both internal and external to the organization, to effectively do the work. This legislation will change that to allow members of multidisciplinary teams to communicate with each other. Only very specific and necessary mental health data will be shared and will be classified as private data. Overall, these changes will help make emergency responders' ability to help people more quickly and effectively in need. I'd like to share an example that the team encountered over the course of the last year. They were dispatched to deal with someone in crisis. Upon arrival with the Rochester Police Department, the client didn't speak English and produced a knife at one point. Because of our existing multidisciplinary team, the specialist team learned that the client was working with an external partner and under the care of a psychiatrist at Mayo Clinic. The external social worker then arrived on scene and was able to translate, and the team was then subsequently in contact with the physician. Being able to relay this information in real time to law enforcement was critical in the ultimate determination of what then happened with that client. After gaining compliance from the client was transported to the hospital without incident and received the care that they needed. In this situation, due to the way that things were escalating, harm wasn't done to the client, to law enforcement officers, or to the social workers that were on scene. Being able to assess the minimum amount of information during this service call was essential. If I may, I'd like to note that not all jurisdictions in our state have the resources to have a co-responder team as we do in Olmstead County, and in those respective jurisdictions, the costs mostly fall solely on law enforcement. We'd like to thank Senator Howe and Senator Bigham for authoring this legislation, and thank you for the opportunity to testify in support. I'd be happy to answer any questions after testimony. Thank you.
Thank you, Ms. Niles. Appreciate your testimony. So our last one, I'm reminded, former colleague, Senator Terrell Clark, now Commissioner Clark. Welcome to our committee.
Thank you, Mr. Chair and members. I am Terrell Clark, Stearns County Commissioner, and I'm also here today on behalf of the Association of Minnesota Counties and the Minnesota Inter-County Association. You've heard some really good examples about this particular proposal and how it's narrowly tailored. In the essence of time, I'm going to give you just one more example, and I do want to reinforce how important it is in these situations that we are both making a difference in helping an individual that's struggling and being very careful with their data. So this is narrowly tailored. All other laws still apply, including the information being treated as private data. So one last example is, and we see this in our area, very proud of the work we're doing with several of the partners that you have already heard from today. So law enforcement gets a call for a non-emergency welfare check. When they arrive on the scene, it appears that the person is in a mental illness crisis. And if they could just call the county and ask if the person is assigned to a social worker, They could provide information to prevent law enforcement transporting the client to detox, ER, or jail, and instead could transport to a supportive family member. We don't feel in-depth medical information is necessary, but the ability to relay and confirm information is helpful. It would help to allow law enforcement agencies, including corrections, county social services, which also includes adult protection, social workers, and medical providers, the ability to communicate with each other and share the following limited information: verifying if the agency or the entity has contact with the individual. If so, provide the name of the social worker or physician, et cetera, who's been working with the individual, and allow these professionals to share ideas and strategies to de-escalate the situation. So like everybody else, I want to thank Senators Howe and Bigham for their work on this and ask for your support, and certainly happy to answer any questions.
Thank you for your testimony. So questions, first up, Senator Bigham.
Thank you, Mr. Chair, and I appreciate the thanks that Senator Howe and I have received on this, but really, the thanks goes to law enforcement. For 5 years, I can tell you that I've been here, well, soon will be 5 years. I've been working on this, Senator Howe's been working on this for a long time as well. And this summer, when Senator Limmer had a hearing with Senator Newman, this was one of the biggest things that law enforcement brought up in that hearing, was about data sharing and about mental health. And I am so thankful to law enforcement for being at the table and talking about this, but then all the other stakeholders, the cities, the counties, and the social services and corrections. I mean, this is really, I think, gonna have a tangible impact on what we hear time and time again, especially in Senator Limmer's committee, that law enforcement wants to help with the mental illness and the mental health calls that are coming. So I think this is gonna be a big help and a big step in the right direction. I thank Senator Howe for carrying the water on this, because I think it was the best shot at getting this passed. And I'm hoping that, I know we have another stop, but I'm hoping we can get this across the line, because after 5 years, law enforcement's been waiting quite a while for this, and the time is now. So I hope committee members will support it. Thank you.
Thank you. Any other discussion?
Mr. Chairman.
Senator Limmer.
Thank you, Mr. Chairman. On page 3, we have a reference on line 16 that law enforcement may not use this information for any other purpose. Elsewhere in that same sentence, there's a reference to chapter 13.02, subdivision 12, and I have a question for council. Is there a penalty for misuse of that information, that health information?
Ms. Primo.
Mr. Chair and members, it looks like that entire sentence beginning at 3.14 classifies these health records as private data on individuals pursuant to Chapter 13. So if law enforcement then disseminates that data in violation of, without any specific authorization in law or court order or consent of the individual, then I believe that the penalties in 13.08 and 13.09 would apply to that.
And what is that penalty, Ms. Primo?
So there is a criminal penalty for willful violations, I believe. And then there are civil and administrative penalties where a person who's injured by the violation can bring an action for damages. And if it's a willful violation, the government entity can be liable for up to $15,000 per violation. And there can also be injunctive relief as well.
Senator
Mr. Chairman,
Limmer.
I think we've had this discussion before. Our privacy laws aren't really good unless you have a penalty for a violation. And sad to say, a few years ago, law enforcement personnel were looking up, the word got out that a particular young lady was of interest on a driver license. And quite a few thousand entries into that driver license, which was only authorized for law enforcement purposes, was violated, ended up in a near $1 million lawsuit and a reward or award given to that young lady because of law enforcement passing around the idea, hey, look at her now. And I think I'm just trying to underline the subject that there is penalties even for law enforcement if they abuse this right. So, thank you, Mr. Chairman.
Thank you, Senator Limmer. Any other discussion from members? Senator Howe, do you have any final comments?
Well, thank you, Mr. Chair, and I want to thank Senator Bigham for working on this bill. And this has been something I've worked on for a long time in the past. And I do believe that this is going to help law enforcement actually assist folks in crisis to actually deal with them in the proper way and get them the help they need. So I think this will be a big assistance, and I ask for your support.
Senator Bigham to HHS.
All right, I will move that Senate File 3193 as amended be recommended to pass and go to Health and Human Services Committee.
On that motion, all in favor say aye. Aye. Opposed, no. The motion prevails.
Thank you, members.
Thank you, Senator Howe. Senator Hoffman, Senate File 1729.
Mr. Chair and members, thank you very much for being here to hear Senate File 1729. And I know that's a late night for you folks, so I'm going to be real quick on my overview and then introduce. We have Keela Murray Grande who's here. Sarah Todd will do the walk through the bill. It'll be less than 2 minutes and 30 seconds, believe it or not, on a DHS bill, Mr. Chair. And then Jennifer Sommerfeld is also on hand in case there's any questions that you need to do a lawyer-to-lawyer conversation on. So with that, Mr. Chair, Senate File 1729 really gets to one of the pieces that we need, which is it gets the pillar of public safety when it comes to non-caregiver sex trafficking assessments in response to child welfare system. And what this does is it modifies the child protection status, Mr. Chair, and provides a response so that it looks at the services that provide greater safety and supports for children and families. In this bill, Mr. Chair, remember we were bringing it up last year and it was going through conference committee and we had to bring it back here, but it's fully vetted in the other body, and it creates a new child protection non-caregiver sex trafficking assessment track in Minnesota law and makes those conforming changes that Ms. Todd will run through out Minnesota statute. The other thing that it does is it modifies the statute as needed to align the non-caregiver sex trafficking assessment that's with current law. And here's the thing I think that's really important, is that these changes include, Mr. Chair, adding sex trafficking to the definition of egregious harm. And so with that, Mr. Chair, I give you Sarah Ladd from the Department of Human Services, who will give you a brief walkthrough, and then Keela Murray Grande will give you her personal testimony, Mr. Chair. So thank you.
All right, thank you, Senator Hoffman. Ms. Ladd, welcome to the committee. If you'd identify yourself and then.
And she's online, Mr. Chair.
She's online,
Yeah.
my apologies.
No, you're good.
I don't see your window yet. I think we're highlighting you now. There you are. Welcome to the committee. If you'd identify yourself for the record and then please begin.
Thank you very much, Senator Hoffman and Mr. Chair and members of the committee. My name is Sarah Ladd, and I am the Human Trafficking Child Protection Program Coordinator at the Minnesota Department of Human Services. I'm here to speak to Senate File 1729, which is a proposal developed by the DHS Child Trafficking and Exploitation Work Group over 5 years. As the facilitator of this extraordinary stakeholder group, I am honored to explain 3 key things about this bill to you. First, children and youth victims of sex trafficking in Minnesota Minnesota today may experience an increased risk of harm due to current requirement that child protection agencies conduct an investigation of all non-caregiver alleged sex trafficking offenders. This includes mandatory contact between the alleged child sex trafficker and the child protection investigator, which often interferes with law enforcement attempts to effect and create serious safety risks for the child victim and the family. Second, the proposed language in this bill would make children and youth safer by removing the requirement for child protection to interview non-caregiver alleged offenders and returning to law enforcement the sole authority to investigate reports of sex trafficking of children by non-caregivers. Instead, child protection agencies would conduct a new response focused on safety and services, the non-caregiver sex trafficking assessment. By prioritizing safety and coordinated services, this bill helps ensure that our children and youth receive the best possible services in alignment with Minnesota's safe harbor response. Lastly, I want you to know that this bill has broad support across Minnesota and nationally. This includes the Minnesota County Attorneys Association, Minnesota Coalition Against Sexual Assault, and Shared Hope International. This bill will bring Minnesota into full compliance with the Federal Justice for Victims of Trafficking Act and aligns with current federal legislation introduced yesterday that would require an alternative response to non-caregiver sex trafficking reports, just like the one we developed in this bill. But most importantly, these changes are supported by survivor subject matter experts and those who work directly with child victims and their families, because they will make Minnesota safer. Thank you so much for your time and for your attention to this bill. Thank you again, Senator Hoffman. I will be on hand to answer questions along with our survivor subject matter expert and advocate, Keela Murray, and another member of our work group. Thank you very much.
Thank you, Ms. Ladd. So you must be Ms. Granda then. Welcome to the committee. If you'd identify yourself for the record and then please begin. Welcome.
Thank you so much. Good evening, Senator Matthews. My name is Keela Murray Granda. Thank you for allowing me to speak. I'm going to make it very quick. I've been doing this on and off for a few years now. I don't lobby, I'm not a legislator, I'm not a lawyer. My background, my master's is in criminal justice, specializing in prevention and intervention, as well as rehabilitation. I am also a survivor, as Sarah said, I'm a survivor subject matter expert, not only of sexual assault, which I've spoken to many in this committee before about for adult sexual assault, but I was also trafficked in Minnesota when my family moved here in the early 2000s, late 90s and early 2000s. Now, a lot has changed since then, right? You'd hope. Not that much, which is really sad. We've done a lot when it comes to taking care of our kids and really providing what they need when it comes to sex trafficking, but we're always learning. And the best response we've learned doesn't always need to come from child welfare. In fact, maybe it shouldn't, because that puts our kids more at harm. Speaking from my own personal experience, as well as the experience of dozens and dozens of individuals that I have worked with over the years, child welfare is already overwhelmed with what they're trying to do. There's already inherent danger in this when you have someone being commercially sexually exploited. And I think that being able to have this bill and this track and being able to move forward, being able to really give authority back to where it should be in these cases, I think is extremely important so we can protect our kids. So that's all I really got for you. This bill is good. I really support it. I'm proud to be here supporting it, and I just thank you for your time.
Ms. Granda, thank you, and thank you for using your voice to be a force for good now. I appreciate you sharing with us. Senator Hoffman, do you have any comments following up from that, or shall we go to committee questions?
Mr. Chair, go ahead to committee questions. We're absolutely, and Jennifer
All right.
Sommerfeld is on one as well, so.
Members, any questions? Seeing none, Senator Hoffman, do you have any final closing words?
Mr. Chair and members, thank you. This really is one of those points that this is what we're about. We're going to protect children, and this really gets that piece into the public safety, which where it needs to be. And I know one question came up there was what's the cost on this? Well, it's $75,000 one time and $14,000 in the base to protect children's lives. And so, Mr. Chair, thank you for hearing this, and if you'd please send it back to Senator Abler's committee with your sticky note that says you shall not touch this. I will abide by that. You have it, and there you go, it's there, so.
Right there, Senator Hoffman, and that's where it's
appreciate
going
you.
back to.
Mr. Chair.
Senator Bigham.
With that, we'll get, thank you for your testimony, and it's a great bill. I'll move that Senate File 1729 be recommended to pass and be referred to HSR.
Thank you, Senator Bigham. On that motion, all in favor say aye.
Aye.
Opposed say no. Motion prevails.
Thank you,
Thank you, Senator Hoffman.
thank you, thank you, thank you.
All right, Senator Johnson, you are up next. Senate File 4318. Senator Johnson.
Thank you, Mr. Chair and members. This will be hopefully very quick. It's a technical fix to help correct some of the, or one of the issues that came up after last year's forfeiture law that we did some changes in 2021. Really what this bill does is it allows for clarification mostly on how service is to be made here. Specifically, Section 1 of the bill clarifies and permits service of complaint challenging asset forfeiture to be made on the prosecuting authority by certified mail, consistent with the parallel provision relating to DWI provisions. So, Mr. Chair and members, if you have any questions, we can go deeper into this, but really that's all the real substance of this is.
Any questions from members or requests for Senator Johnson to read the bill verbatim? Hearing none, Senator Johnson, I think you can move your bill
I move.
to the floor.
Senate File 4318 to be recommended to pass and move to general orders.
Senator Latz.
Sorry to be late here, I just read the bill, which took all of 15 seconds, but it looks like it's allowing service as permitted by the rules of conciliation court procedure, right?
Correct.
Rather than requiring it be by mail. So does that cover certified mail and other procedures as well?
Senator Johnson.
Mr. Chair and Senator Latz, that was my understanding.
Okay,
Senator Latz.
that's all I had, thank you.
All right. Any other questions, members? Senator Johnson renews his motion for Senate File 4318 be recommended to pass and referred to general orders. On that motion, all in favor say aye. Aye. Opposed, no. Motion prevails. Senator Bigham, Senate File 2307.
Let the grilling begin. Mr. Chairman,
Senator Latz.
this might be one of Senator Bigham's last bills being presented to a committee. As a senator, I think we should be careful to scrutinize this bill extra carefully.
I agree, Senator Latz.
Oh, Senator Latz,
Perhaps you want to
I have a
read
feeling
the
that was
bill.
naturally gonna happen, whether it was my last or not on this one.
Senator Bigham, welcome to the committee.
Thank you. Members, I have Senate File 2307 today, and this is an important bill. This is a bill that strives to protect educational data for students and really, sorry. You're good, thank you. It's really there to make sure that the apps and the technology that students use in schools, public schools, after we do the amendment, will be protected, and that parents will have authority to opt out. If they feel the data is being misused to solicit their children for, you know, toys, other material, whatever, you know, they can get on a list and submit it to based on the apps that the students use. So I am gonna have Julia Decker from the ACLU speak and kind of help summarize the bill. But really, it imposes educational data privacy protections on technology providers who contract with schools to provide technological devices for students' use and that receive educational data pursuant to that contract. The bill also prohibits electronic access or monitoring of school-issued devices unless an exception applies. And Mr. Chair, I would offer the A2 amendment to get the bill in the form that I would like. It is an author's amendment, and this is the committee of original jurisdiction.
Senator Bigham offers the A2 author's amendment. All those in favor say aye. Aye. Opposed, no. The amendment is adopted.
Thank you. And Mr. Chair, I'd also like to thank you and Senator Limmer for being co-authors and Senator Kunish. With that, I would ask Ms. Decker to say a few words about the bill.
Ms. Decker, welcome to the committee. If you'd identify yourself for the record and then please begin.
Thank you, Mr. Chair. Julia Decker, Policy Director for the ACLU of Minnesota. This bill, Senate File 2307, is the result of several years of intensive bipartisan work and discussions with stakeholders in both the privacy arena and the education arena. We're very grateful to Senator Bigham for carrying this bill, to the chair for hearing it. Over the interim, the bipartisan bicameral Legislative Commission on Data Practices unanimously recommended this bill to the legislature to be passed. The first part of Senate File 2307 limits what technology companies can do with student information and prohibits them from selling that information or using it to advertise or market to students. It provides students and parents the ability to opt out of sharing their information in certain instances and requires return or deletion of data upon termination of a contract between a technology provider and a school. The second part of Senate File 2307 limits the use of certain invasive surveillance tools, such as location tracking of a school-issued device or remote access to a web camera on a student's computer while it's sitting in their home. Schools cannot use these surveillance tools unless one of the specifically enumerated exceptions applies. There are exceptions for an imminent threat to life or safety, in the case of a stolen device, to comply with federal or state law, if there is a judicial warrant, and for remote classroom or distance learning activities, the Zoom classrooms that have become so ubiquitous. Technology is developing and being deployed far more rapidly than our laws can keep up with. Student information that used to be kept on paper in a locked file cabinet can now be collected, maintained, and even sold by third-party technology providers. In addition, increasingly powerful technology makes it easier and easier to conduct secret, warrantless surveillance. Senate File 2307 constitutes an important and critical move toward protecting students' data privacy in Minnesota. It's urgently needed, and while the best time to act on this issue was before these tools became so pervasive and so invasive, the next best time to act is now. So thank you, and I will stand for questions after testimony.
Thank you, Ms. Decker. Next will be Andy Liddell. Hope I pronounced that correctly, and I believe you're online.
Yes, thank you, Chair Matthews, and you pronounced it perfectly, which doesn't often happen. So thank you for inviting me to testify tonight. For the record, my name is William Andrew Liddell. I go by Andy, and I can't seem to change my Zoom name, so that's why you're seeing William up there. But I'm a technology lawyer and a digital rights activist from Austin, Texas, where I live with my wife and 2 young kids. And I co-founded the Student Data Privacy Project, which is a grassroots parent effort to understand what information is being collected about our kids by tech vendors at school and what is being done with it. And last year, we coordinated an effort by 14 families in 9 states to exercise their information access rights under the 1974 federal FERPA law. What we learned was shocking. Despite clear requirements to make this information available to parents upon request and to limit to whom that information is given and how it can be used, not a single school district from Alaska to Maryland, and including Minnesota, gave parents the information they're legally entitled to within the time limits required by the law. Some districts simply ignored the requests. Others referred parents to the technology vendors, who then ignored the requests. Others involved their district's chief technology officer and made good faith attempts to comply, but were refused by the technology vendors. Still others were unaware of their obligations under FERPA and tasked the superintendent's administrative assistant with responding. Here in Minnesota, one family received over 2,000 files about their young daughter, representing just a small portion of what was requested, but which included such things as baby pictures, videos of her in an online yoga class, her artwork, and her answers to in-class questions. The family was given no information about how long this information was to be stored, to whom it was disclosed, or for what purposes it was being used. Today's digital products, including those used in school, collect a staggering amount of information about their users. This includes grades for every assignment and disciplinary records going back to kindergarten. It includes every search, every website you visit, and every person you interact with. It also includes every mouse movement and how long you linger on an image. Truly, every single thing you do on a computer, all of this information is fed into an algorithm that is used to build a digital model of you. This digital you not only determines what you experience in the digital world, but also what opportunities you have in the real world. Everything a child does on a computer for the 13 years they're in school is subject to being collected in this way. While this vast trove presents risks for hackers, I'm most concerned about how the currently legal uses of this information are shaping this generation of young people. These digital models of our kids are used in life-altering ways, including to determine which students will be recruited by a selective college and which will be referred to the local police. Currently, there are no practical limits to how this information is being used and no assurances that the information is accurate before it is disclosed to those who make life-changing decisions about our kids' futures. A state of constant surveillance is a threat to freedom, democracy, and healthy development. The Center for Democracy and Technology reported in the fall of 2021 that lower-income students and students from Black and Hispanic families were more likely to be surveilled at school and were disproportionately disciplined for their online activity. And that same report showed that most children now agree with the statement, "I do not share my true thoughts or ideas because I know what I do online is being monitored." Senate File 2307 creates a healthier digital ecosystem for the school children in Minnesota. By legislating that student data is not the property of technology vendors, and by limiting how that data can be used, and by sharply curtailing the surveillance of students, this bill safeguards the freedom and self-determination of the children of the state. I urge you to support it, and I'm happy to answer any questions. Thank you.
Thank you, Mr. Liddell. Our next testifier will be Rich Newmeister, and then following him, Caitlin Snyder from Education Minnesota. Mr. Newmeister, welcome back.
Chair Matthews and members of the committee, my name is Rich Newmeister. I just want to say it's been almost a half a decade that these kind of bills have been introduced. And as a reference was made to the Privacy Commission, I forget the incarnation of what it was called before it was, but it's been there for a while, discussed. It was when it was proposed a number of years ago, it was a multi-page bill. Now it's been narrowed here. It's been the work on the House side, and I'm sorry to mention the other body, but that's, both bodies do sometimes help each other out to clear a lot of the issues, and the other body generally adopts some of that language. The House has done a lot of work in a bipartisan way to where it's important to continue to pass this bill. As Representative Lucero said to me, as I was talking to him about it today, he says, it's important to get something like this on the books because we're in 2022 and all the information is no longer in the paper stuff. It's in the pad, the software, and those kinds of things. So, Chair Matthews, members of the committee, There's still gonna be some folks, they're gonna say, nah, this, that, that's fine. It's America. But I just want to share with you, this is a very strong privacy bill with parents' rights recognized, individual rights recognized, and the ability to start dealing with this kind of issue in 2022. So, and they even accepted some of my amendments too, which were important too. So, Chair Matthews, I encourage it. And I just also want to say, because this will be my last time that I'll be testifying in this incarnation of data practices, I thank you for having a hybrid process, an open process that Democrats and Republicans have had continue on these important issues of data, because data has impact on lives. So once again, I thank you. And we'll see you maybe next year.
Thank you, Mr. Newmeister. Appreciate your continued input on a number of issues we deal with in committee, and glad to have had you in person all these times here this year as well. Next up, Caitlin Snyder. I believe you are remote. There you are.
Correct.
Welcome to the committee. And then Sarah Cloak, I hope I'm pronouncing that correct, will follow. So Ms. Snyder, welcome to the committee. If you'd identify yourself for the record and then feel free to begin.
Mr. Chair and members of the committee, my name is Caitlin Snyder, lobbyist with Education Minnesota. We represent 86,000 educators across the state in every district. As we all know, technology is an important tool in the classroom and there is no going back. However, just as last year the legislature looked carefully at limiting screen time for our youngest learners, we also need to make sure that we preserve student privacy as we move into a new learning mode. The provisions that we want to highlight as particularly appropriate include language ensuring that third-party contractors comply with the Minnesota Government Data Practices Acts as if they were private public entities, which means storing and protecting what will almost always be private educational data. We also share Senator Bigham's concerns about off-campus monitoring of student conduct and the gendered and racial discriminations that may unintentionally take. Additionally, we know that both here in the Senate and in the other body, the authors have worked tirelessly to address the concerns that some advocates have raised in prior discussions. The language adopted in committee today will allow in-class activities largely to the same degree that we all enjoy now, and there is language that will permit the use of school information systems for all students. In prior discussions, some opponents of these protections for students have suggested that the work of creating alternative materials or experience for students will fall on our teachers. All adults in schools are responsible for meeting students and families where they are at, and our members will not be solely responsible for any minor accommodations this legislation will require. This is both a statement of fact and a prediction for the future. Thank you, Senator Bigham, for bringing this forward, and thank you for hearing this bill tonight.
Thank you, Ms. Snyder. So next is Sarah Cloak, followed by Anthony Patternus. Ms. Cloak, are you on our Zoom screen?
I am. Hello.
There you are. We're trying to highlight you so you can
That's
be seen.
okay.
There you are. Welcome
There
to the
I am.
committee. If you'd identify yourself for the record and then feel free to begin.
Sure. Hi, everyone. My name is Sarah Cluck. It's pronounced cluck like a chicken. No offense. I've been doing that for 30 some odd years. So I'm the Senior Director of Education Policy at the Software and Information Industry Association, a nonprofit trade association representing education technology companies. I'm also a proud graduate of Minnesota's public schools, spent 4 years in Senator Westrum's district at the University of Minnesota Morris, and the daughter of a retired paraprofessional in District 834, Senator Bigham's, represented by Senator Bigham's. So I am happy to have such great representation on this committee. I've also served as a fellow at the U.S. Department of Education, charged with focusing on the Family Educational Rights and Privacy Act and the Children's Online Privacy Protection Act. I want to quickly respond to what was said earlier. The existing 1974 Federal Family Educational Rights and Privacy Act does prohibit the selling of student data. It's already on the books. It's prohibited by federal law. I appreciate what Ms. Snyder was saying. I am not going, my organization still has concerns about lines 4.1 to 4.3, but it's late, so I won't take up your time on that. My organization is also concerned about lines 314 to 315, which prohibit a technology provider from using any data for any commercial purpose. Generally, this is a really good idea. We support prohibitions on the use of data, but the language is not very clear. There was a bill proposed in 2017. It was in 2017, it was Senate File 1961, which actually had more strict language, and it was a lot more clear in what companies could and could not do. It would include a number of things, including preventing a company from amassing a profile about a student except for school purposes, and prohibits targeted advertising using any information the company acquired due to a relationship with the school and student. Senate File 2307 currently prohibits using educational data for any commercial purpose, including advertising to students and parents. That's a lot of words, but the 2017 bill was more specific and provided broader protections to a broader amount of data. There's a few other areas of concerns, but in the interest of time, I know there's other people that want to testify and there's a lot going on. So thank you for your time and thank you for hearing me.
Thank you, Ms. Cluck. Our final testifier is Anthony Patternus, and I believe you are online as well.
I am.
There you
Good evening,
are.
Chair Matthews and committee. I'm Anthony Patternus, the Executive Director of Technology for Osseo Area Schools. I'm here today as a former teacher, current district administrator, and parent of school-aged children to speak on behalf of the Minnesota Association of School Administrators, the Minnesota K-12 Technology Leaders, regarding concerns with Senate File 2307 that, if not addressed, would cause us to oppose the bill. Our significant concerns are with the language as it extends to school professionals and our ability to operate schools with district-owned and provided technology systems. This language treats school professionals and technology companies the same. These concerns are also shared by MSBA, AMSD, MREA, SEE, and the Elementary and Secondary Principals Association. Minnesota has board policies, state laws, federal laws, and codes of ethics regarding how we, as school districts and district employees, are responsible for ensuring data privacy and protections. Many examples that have come up relating to technology use overreach by school officials are often already prohibited by these policies and laws. In Subdivision 13, the opt-out language would create significant burdens on teachers' ability to instruct with digital tools, including the teaching of state standards that require engagement with technology. It would require daily teachers to develop alternative lessons for students who opt out of essential instructional tools. This language also causes significant challenges to operations. For example, most aspects of school management, such as report cards, GPA calculations, class ranks, transportation, IEPs for special education, and scheduling students occur within a school information system, and often multiple systems. If students are able to opt out of these systems, it would create a major disruption to the basic school functions. It also causes challenges for a district's ability to provide learning through e-learning days and for state-approved online providers as allowed through current state statute. Online 4.1, if applicable, is being presented as a way for districts to determine when technology solution is necessary for operations and can't be opted out of. It is also our understanding that this flexibility doesn't apply to systems for instruction. In consultation with our district legal counsel, greater definition in this bill's language is necessary because if applicable is vague, causing ambiguity, it makes it unclear to districts and families as to what is allowed. In Subdivision 14, the amended language on monitoring is a step towards providing greater flexibility to school districts, but still poses limits that may prevent our ability to ensure cybersecurity and appropriate use of district-provided hardware. As school leaders, we share a common interest for the security and privacy, and we have been working diligently for years to increase these protections for students, families, and staff when it comes to district-issued technology and technology systems. This is a priority that keeps many of us up at night. We agree and support the bill's language regarding the expectations for technology companies and believe that language is a great step in supporting our work holding these companies accountable. That language supports what many of us are independently negotiating into vendor contracts already and follows 40 other states that have adopted laws to improve privacy and security in the K-12 setting, with 26 having adopted common language under the Student Online Personal Information Protection Act. Thank you for your time and consideration this evening.
Thank you for your testimony. Senator Bigham, any comments following up on that?
Yeah, before you get to member questions, a couple things. One, I neglected to say that this was passed and supported out of the Data Practices Commission this last year. And for those of you keeping track, that's rare, that there is something that comes out of there that, you know, in a bipartisan manner that passes. I think drone thing maybe 4 years ago was one of the last pieces of legislation that came out. So just want people to know that the Data Practices Commission gave a lot of thought to this. And, you know, this started as an opt-in. And in order to address concerns that have been mentioned, we switched to an opt-out. And I just have to say, I think the only option they want is to not have it in. And that it's the whole crux of the bill. And it says if applicable. That's what it means. If there is a software that is keeping track of a schedule, of report card, of you know, the parent, who the teacher is for the kid, so the parent knows that, it's not applicable. I mean, you need that. We're talking about the apps that are used that then sell that data so that it could be used for commercial purposes. That's what we're talking about here. That's what we're trying to protect. And so, you know, you shouldn't have to decide whether to send your kid to a public school and whether Google is going to sell their information and start soliciting them for products. That's just not right. So, you know, I don't know if Ms. Decker has anything else to add. Otherwise, we can start with questions.
We'll go to committee questions. Senator Johnson.
Thank you, Mr. Chair. And Senator Bigham, I just want to follow up on what you just said here too. We heard from a testifier that selling of data is prohibited based on federal law currently. Could you tell me if that isn't being followed currently by the tech companies, or if that was a misstatement by the testifier that we just heard from here? Well, I don't remember who it was.
Senator Bigham.
Thank you, Mr. Chair and Senator Johnson. All I can tell you is the data is being used to solicit products, and there's testimony in your packet, a letter. So I can't tell you if the law isn't being followed or if it was a misstatement, but it's happening. So clearly it's not being enforced, I would say that, or reported, maybe by the apps.
I have a couple hands online that want to weigh in on that question. Why don't I do Ms. Cluck first and then Mr. Liddell?
Sure, I'm happy to provide the reference to US code. FERPA is 20 US code section 1232G. And there's a bunch of guidance from the US Department of Education on selling of data. There's a specific one that came out in 2014 and how they recommend education technology companies can need to treat data. If a company is mistreating data, and the US Department of Education is charged with investigating that, and the US Department of Education can ban an education technology school from using that particular education technology company for 5 years or more. And I can tell you a company does not want a press release going out saying that their company has been banned from a school. That would be very bad. Like I said, it's already banned. I'm happy to provide the reference to the materials from the US Department of Education if you want that. I can send that your way. I just need to bring up the links on my computer.
Thank you. Mr. Liddell.
Yes, thank you, senators. So a few things. This practice may be banned, but it doesn't mean it's not happening. A 2021 report by a nonpartisan, unaffiliated group called the Me to Be Alliance analyzed the apps that are being used in public schools across the country and found that over 2/3 are leaking or selling data in some way beyond the scope of what is legal. Beyond that, while this may be banned, it's not currently being enforced. The Department of Education at the federal level tends to take a pretty light hand with a lot of this enforcement. And so where the federal government refuses to act, it would be wonderful if the states would step in. And then a third point, technology vendors tend to apply a very narrow definition of what the word sell means. And they mean that I have this information, I sell it to you, I no longer possess it, and it's yours to do with what you want. And of course, that undermines their entire business model. What instead happens is they license others, third parties, to access that information. So I have it, you pay me some money, you can look at it, you can use it however you want to. And to a normal person, that's the functional equivalent of a sale. But these technologies these technology companies and their attorneys tend to use this very creative language to really get around the federal law, because they can say technically we're not selling it, and technically they're not. But the difference is immaterial, because whether it's being sold or whether a license is being granted to third parties to do with what they will, the result is the same. Children are being marketed to, their information is being gathered up and sold to data brokers, and that information is being used in ways that harm them without their knowledge or consent, or without the knowledge or consent of their parents.
Mr. Chair.
Goes back to Senator Limmer's earlier comment about our data privacy laws are only as good as how they're enforced.
Yeah.
Senator Bigham.
I would just add, Mr. Chair, Senator Johnson, it doesn't hurt to put it in state law too. And so, I mean, I think that's what we're doing here. And, if this is passed into law, it'll be one of the leading efforts in protecting student data privacy. And I think that's where we want to be, and Minnesota can lead on this. So I think we should keep moving this forward and working towards that goal of protecting the student data.
Senator Johnson.
Thank you, Mr. Chair. And Senator Bigham, I think you're right. If it's the same protections that we can put into law, it doesn't hurt. But I worry about the expansiveness of this and the definition. I had a couple of questions. One was on 3.14, but I think those questions were already asked with the any commercial purpose. Without commercial purpose being defined in any is such a broad term. But if you go up to 3.9 through 3.13, a technology provider must not sell, share, or disseminate educational data. To me, I'm a little bit confused on what that means. Does that mean even within the classroom, if it's a student working on their computer, are they able to still share the data that they create with their teacher as far as grading, academic work, those sorts of things as well?
Yeah, Mr. Chair.
Senator Bigham.
Yeah, definitely. I mean, that's not the point of the bill. The point is to prohibit them from commercial use of it. And I don't think that is actually broad, but, one other thing that just popped in my head, Senator Johnson, when you're bringing that up is there's no reason to believe that parents will suddenly opt out of using any of the software tools or such, for school use to teach their kids. Because if all of a sudden they did, then there's probably something wrong with that software that they would be concerned about, with multiple parents worried about that. So I think when it goes back to the commercial use of it, that's where the concern's gonna be, not the everyday use, as I said before, where they're grading, where they're, knowing who the teacher is, checking the schedule, doing all that.
Good.
Senator Johnson.
Okay, last one here, but So, you know, and I'm new to this, you've spent a lot of time looking at this, so I'd like some help with this too. Could you show me where it's permissive then for that data to be shared with a teacher, and others that might be a supporting staff within that classroom or for that student then, please?
Ms. Decker, are you asking to take that question?
Mr. Chair, Senator Johnson, so the first part of the bill, which talks about must not share, disseminate, that all applies to technology providers. It doesn't, and so schools are not considered the technology providers. The second part of the bill, which talks about surveillance tools, is where we are talking about the school-issued devices, and therefore the schools are the ones that are being limited in what they can do. So we're talking about the technology in the first part when they're, the companies, you know, we're not saying they can't collect data when they are contracting with schools. What we're saying is when they get that data, they can't be sending it out willy-nilly without any, you know, just without any limitation. So there's two different entities that we're talking about within the bill, technology companies and schools, and they are not one and the same.
Anything more, Senator Johnson?
I'm sorry, so I just want to clarify that. So if I'm a technology company, which this does address, so if I'm, whatever, Big Ed that's working on this, so I've got this data, and it says to me, I am not allowed, a technology provider must not sell, share, disseminate educational data. And then there's some exceptions within there. So, but still at the same time, so does that cover me then as a big tech company from sharing it with anybody? Or do I have to keep it solely to that student and I cannot share to the teacher within that?
Ms. Decker?
I'm not sure I understand the question. So are you asking if it's because it's going to a server? Is it now being?
I'm looking at
Senator
disseminate,
Johnson.
so which simply means, you know, sending it outside of my control again. So now I'm taking it from the student and I'm sending it over to the teacher or administrator or somebody outside. Is that allowed within this bill?
Ms. Decker?
Yes. So the dissemination is applying specifically to the technology provider to another entity. So when we're talking about a technology provider holding that data on their server, that's, and then, you know, a student accesses their file from a cloud server, that's not dissemination. Does that answer your question, Senator Johnson?
Potentially because the technology provider would have a contract with the school.
Yep.
I'm getting head nods to that. Anything more? Okay. Thank you, Senator Johnson. Next, Senator Latz.
Thank you, Mr. Chairman. I had a question that was raised by one of the testifiers, and maybe I can get a little more clarity on it. On line 4.6 of the bill, it does make reference to not withholding an educational benefit. My note here was, what is the benefit? Or what if the benefit is only provided in a digital form? How is that to be handled? I think the testifier said, or raised concerns about having to recreate educational lessons in non-digital forms for everyone who chooses to opt out of the digital form of it. But maybe I can get a little more clarification on that, because that would seem to me pretty burdensome if it turned out to be more than one or two kids.
Senator Bigham.
Thank you, and thank you for that question, Senator Ladd. So it goes back to the if applicable again. And sometimes they're no longer having something bound by book or, you know, paper side. It's only gonna be on the app. So therefore, you know, that would be allowed because it's not applicable if they don't have that in a paper form or an additional form, unless I'm getting this wrong. So no, I'm not. I'm being told that's accurate. So that's an example of if a book they need is no longer, you can no longer obtain it in a paperback or hardcover, and it's only allowed on, online on a tablet, that would be allowed. So I'm
Ms.
just using that as an example for, as applicable or if applicable.
Ms. Decker, are you looking to add to that?
Mr. Chair, Senator Latz, additionally, just to build off of that, if we're talking about something like a technology education class, for instance, where it's the education that's, the class itself or the curriculum itself is about technology, then if applicable would also apply, because of course you can't learn about technology if you've opted out of using the technology. I would also point out that the concept of opting out is not new. It already exists in Minnesota state law. Parents are already allowed to opt their children out of certain types of curriculum. And so the concept of being allowed to not do something, even within the education arena, already exists in state law.
It also appears Ms. Snyder on the Zoom call wants to weigh in on the question.
Thank you, Mr. Chair. Senator Latz, I read that language is talking about you can't withhold, say, a student's right to be on the honor roll or other sort of benefits more so than its impact on the instruction in the class. So I think I read that language as being outside benefits, not relating to the curriculum.
And now Mr. Patternus briefly.
This goes to the challenge that we raised in our testimony and our concerns of the vagueness of if applicable. So as I've listened here, we've heard about student information systems, and now we've heard about instructional applications that could be out of the realms of allowing opt-out. So we still see significant concern in the vagueness of the way that this is written and how we're going to provide clarity in operations within a school district. We do have a lot of curriculum and textbook that are now all in a digital format. If you think about the Minnesota social studies standards and Minnesota history taught in 6th grade, that is primarily delivered by most school districts in a digital format because there is not a textbook for Minnesota history within our state. So there are a lot of examples in terms of curriculum and within state standards. Our ELA, English Language Arts Standards, has media literacy built in K through 12, where students need to engage with technology in order to learn digital citizenship and appropriate use. Our new science standards that are in the process of being adopted have coding built in, kindergarten through 12th grade, so students start to learn the logic of coding, which has, again, requirements of us as districts to engage with digital instructional tools with our students.
Mr. Chair.
Senator Bigham.
Goes back to the crux of the issue. If students have to give up their information to get a public school education, then that's wrong. You shouldn't have to choose. So it just goes to the crux of the bill.
Any follow-up, Senator Latz?
Yeah, I'm trying to, first of all, maybe I can get Senator Bigham to clarify what she means by that last comment, and I had some other follow-ups on the testifiers.
Senator Bigham.
Yeah, Mr. Chair and Senator Latz, if there's an app, I mean, the administrator just said that it's only an online version. Great, that's going to be okay because it's applicable. If not, and they're worried that parents are worried that information is going to get out of the and be sold for commercial purposes, in order to get a public school education, that is just, it's not okay. And these apps are going to be fine as long as it's applicable to the educational side of it. They're worried that all the online materials are gonna be gone. I mean, this is a contract between the educators and the ad companies and the software companies. So it's just not, the example he uses is not going to apply here because it's only on an online form to teach history and the standards. It's going to be fine in this bill.
Senator Latz.
So, Mr. Chairman, I'm having trouble. It sounds to me that reasoning is a little bit circular. I mean, if the core of the bill is one thing, but it's defined in a way that it's very difficult to determine what applies and what doesn't. I think the solution is to try to more clearly define what's allowed and what's not allowed, if you really want the core of the bill to be effective. So if applicable, to me, is a pretty vague term. And when I read this, first of all, I don't see necessarily how it applies to paragraph J, because it's in paragraph H3 is the applicable provision. But nevertheless, that to me is hard to understand. And it does say any program or activity. So the opt-out provision is any program activity that allows curriculum, testing, or assessment technology provider to access a student's educational data. Well, that's everything. My daughter is in 8th grade. She's got everything on her iPad. And I can access everything on Schoology, or Skyward, or the systems through the school district's digital website. And I don't know who's going to decide what's applicable or not, but it sounds like an area that's could end up being very ripe for litigation. I'm not sure I want courts to have to wade in and figure out what's applicable or what's not applicable either. On line 4.6 and 4.7, the definition of an educational benefit, well, we just heard one testifier say that in her mind, that's referring to something like the honor roll, which would be, it's important, but it's ancillary to the core function of educating. But to me, the core educational benefit is learning the content of the curriculum. And this language doesn't say that. And so I think you've got, I don't know how you make that work, honestly. And I mean, I don't want to be in a position where you've got someone who is so nervous that all of the digital data is going to be improperly used or accessible. They have a right to a public school education in Minnesota. No one can force them to go to a private school. This isn't about accessing the content of the curriculum, it's about the form of the curriculum. So I don't see an analogy to parents' rights to learn what's in the curriculum and to opt out. I don't see the opt-out as something we can use as an analogy here for other things. Because when they opt out of a particular piece of a curriculum, say they don't want their student to learn the sex education curriculum in the school, or certain content about American history, if I remember right, I think we dealt with this in this committee, the statute requires the parents then to provide supplemental or alternative information themselves. They still have an obligation to teach the child something related to it, if I remember right. I don't know, if this is the core of the bill, I appreciate what the bill is trying to do, but if this is the core of the bill, I think it's not drafted tightly enough to provide the clarity to the users, either to the parents or to the schools in terms of how to comply. I have also a drafting question, and maybe I'm not reading this right, but line 4.1, this is a notice requirement that says must include information about the contract inspection and, if applicable, a right to opt out. But all that is a notice provision. Is the right to opt out codified somewhere else in this bill? I mean, the substantive right itself, not the notice about it.
Senator Bigham.
Mr. Chair, I would ask counsel, but I don't believe so.
Ms. Primo, do you have advice?
Mr. Chair and members, the specific right is not codified anywhere else in the bill outside of, in that notice provision when it's provided to the parent or student.
Senator Latz.
So, Mr. Chairman, Ms. Primo, as you read this provision then, does a notice provision create a substantive right?
Ms. Primo.
Mr. Chair and members, it's really, that part is unclear to me. It does require that the notice state that the parent has the ability to opt out, but does not necessarily independently state that the parent does in fact have an opportunity to opt out. So I think that's unclear.
So,
Senator Latz.
Mr. Chairman, I just think as a matter of the codification of these provisions, I'm not sure, I guess it kind of presumes, if there were an opt-out in a different section of the law, it could say to opt out under Minnesota statute section 245C.03, and that might be where a substantive right is contained, or subdivision 10 or something like that would be where the substantive right is. But I don't know that you can create a substantive right by referencing it in a notice provision. So I may be wrong on that, which is why I inquired of counsel. Maybe there are others more learned about this than I am, but I'm not sure from a drafting standpoint whether that even accomplishes what the authors are intending to accomplish. I say, I believe we do need to get something on the books about this stuff. I mean, technology is way ahead of the law on this. And I know this has been in the works for a long time, and Senator Bigham's just been working really, really hard, and all the stakeholders have been working really, really hard on this. But I've got these concerns about this going forward. And I'm not sure I'm comfortable letting it go forward. It's not going to receive this level of scrutiny on the floor. I can be certain of that. And if it goes forward as written, I don't know that I'm comfortable saying, let the stakeholders figure out some alternate language. And we'll take a look at it on the floor.
Mr. Chair.
Senator Bigham.
One, could you confirm, or your staff, that this is actually going to education?
It's getting referred to the Education Committee.
Yeah.
So this will end up as a late bill then? Is that, or is there
I
a
believe
fiscal note
that,
attached to it that's?
I believe the Education Committee is putting their bill together on Monday. And that's likely the path that this bill was intending to travel.
So, Mr. Chairman, I would assume that the education bill will be a combination policy and finance bill. I assume so. Its deadline would be a week from tomorrow, presumably.
I believe
See Senator
so.
Bigham's nodding her head. I mean, that's the only way it'll meet deadlines. Otherwise, it becomes a late bill, which just means it has to take an alternate route. But these are quintessentially, I mean, this, certainly, I think the paragraphs we're working through right now are within this committee's jurisdiction to try to get right. I'm not sure I'm comfortable punting it over to the Education Committee either, for these issues anyway.
Mr. Chair.
Senator Bigham.
Thanks. Just wanted to make a couple points. One, Senator Latz, when you mentioned that your daughter has the Schoolly app or whatever, so all that data is collected on her and could be disseminated. And if there was a bad actor app, software company, whatever, that did that, you should have the right to opt out of that. And it shouldn't, an education shouldn't depend on the requirement to not do that. Here's my second part. It's late, so I wasn't articulate the first time, so I appreciate, the second to wake up a little bit, and it's been a long day. I will say this, that We have offered to get more explicit in the language. It's rejected. We started with an opt-in, rejected. So the opt-out is what we have discussed on how to best move forward on this. So that's kind of where it's at.
So, Mr. Chairman,
Senator Latz.
I'm not sure whether offered to get more explicit, but it was rejected means. I mean, either we have a bill, I mean, if we don't have a stakeholder agreement, it's apparent that we don't on this bill. Then all that means is that they didn't have sufficient agreement to bring all the stakeholders in and chose to proceed anyway. So I think it's kind of important also in a bill like this to try to get the wide variety of institutions and stakeholders that are going to be required to comply with it on board in agreement in the sense that it can actually be administratively implemented, or is at least specific enough to provide clear guidance on it. I know we pass stuff around here all the time that doesn't have everyone agree, all the stakeholders agree, but I didn't catch the whole list of acronyms that we had, the testifier from the Osseo schools, Mr. Patternus, was speaking on behalf of, and I guess maybe I can get a little clarification if there was, he kind of ran through the acronyms pretty quickly. If I understood correctly, I think he was saying he was speaking on behalf of a bunch of different stakeholders, but
And Mr. Chair.
it's a large group to not be included in something like this. And I totally agree with what Senator Bigham was saying. I don't want this data to be out, on my daughter to be out there commercialized either. I understand the urgency of this, but if we're gonna do it, we should get it as close as we can to doing it right.
Senator Bigham.
Mr. Chair, what I mean by explicit is we could continue to try and narrow this, but the fact of the matter is they don't want the provision in there at all. They want the software companies to deal with it. And we've already been told, like, if this is already happening, Senator Johnson's line of questioning, right? So somebody has got to be able to protect the data of these students. And so this is the option after a bunch of discussion. So that's where we've landed on this, and would certainly appreciate the committee's support to move it to the Education Committee.
Well, Mr. Chairman.
Senator Latz.
I'm not sure I'm comfortable with the software companies making the decisions either, but.
Right, right.
It seems to me there must be some room in between here to provide a little more clarity on it. But I think we might have another testifier who can shed some light on this.
Are you wishing to speak to this question?
Yes, please, Mr. Chair.
If you would please identify yourself for the record.
Thank you, Mr. Chair and members of the committee. My name is Valerie Dosland, and I represent the Minnesota Association of School Administrators. But as Anthony Patternus shared, a large acronym of organizations. They include the Minnesota Rural Education Association, the Association of Metropolitan School Districts, the Minnesota School Boards Association, the Principals Associations, and Schools for Equity in Education. I do want to just correct the record. I think I heard Senator Bigham say we rejected a change. We continue to ask for change and ask for more clarification. And as we have said in numerous conversations with the stakeholders, we have asked for clarification on what if applicable means. And as Mr. Patternus had explained, we have numerous systems that school districts use today, such as student information systems, student transportation routing systems, special education forms, that if a parent chooses to opt out of those systems would be extremely problematic. And we've also even explained to the stakeholders if we can get this clarification on what if applicable means, and we have even suggested specific language on what we would like to see that parents cannot opt out of. That has been rejected. So I appreciate the time and I'm available for questions.
Thank you. To this issue, Senator Limmer.
Mr. Chairman, I've asked counsel to determine if she could write a clause that would recognize a substantive right prior to the paragraph J. I'm not sure if that's the right location. She's working on it. She needs a little more time, but hopefully as we continue to discuss this, it might be something that might satisfy that question.
All right, thank you. I also see Mr. Liddell has your hand up online.
Yes, thank you, Mr. Chairman. So I'd like to address a couple of points that Senator Latz raised, specifically with Schoology. So in our experience with the Student Data Privacy Project, Schoology was one of the biggest offenders, frankly, that completely stonewalled all of our requests for information and then continued to stonewall the requests for information from school districts. So their position was, we don't have to tell anyone anything about the information we have about the students that are using our products. There's an article in a publication called The Markup earlier in January where, some of the sources were former Power School employees that leaked internal information. And it became clear that Power School has many ways of making money and doing their business. So one way that certainly my group thinks is entirely appropriate, and that I think would be acceptable under this bill, is charging school districts fees for service. That's fine. You need your administration programs, your enrollment forms, your attendance tracking, all of that. That's necessary. It does make it easier to have that done on a computer. Another way that Schoology makes money, I would say is less acceptable, is they take all the information across all of their many platforms. Schoology was actually bought by a company called Power School, which itself is owned by a big private equity company that owns a number of ed tech companies, and they all have data sharing agreements amongst themselves, as was reported in this January article in the Markup. And this is where the data sale is happening. They are selling this data to marketers, and they are selling it at least to marketers. And we know that also it's likely that it's going to other third parties as well, including local police, including the military for recruitment purposes. And it does include information starting from kindergarten that is collected and rolled up into this giant database. And there is a vast middle ground between what is acceptable and what's required to run a school in 2022, and this profiteering data grab that's currently happening. And this bill would put a stop to the latter. So I don't want to overstep and start getting into drafting points. Adding a substantive right, I think, would be clarifying and helpful. I understand the difficulty of trying to get more specific as well, but that really is the harm. So keeping track of students with special educational needs, there are certain things that obviously you can't opt out of, that this is just how things are administered. But the things you can't opt out of can't then turn around and be sold for profit.
Thank you. I believe if Senator Latz, if you had a follow-up, and then Senator Carlson's on our list as well.
Well, Mr. Chairman, I worry about leaving it entirely up to the school districts to make sure there's a contract term with their data technology providers that protects student data privacy as well. And I will note, if nothing else, there'd be a financial incentive for school districts to allow certain data sharing or commercializing if there were some remuneration from the data host back to the school district in return for that ability. We don't fund our school districts enough anyway from the state. I wouldn't want that financial incentive to be in place to supplement school district budgets. So I don't have a problem with setting a state requirement in that regard. I just think we need to do it in a way that is administrable.
My understanding is Ms. Primo has something ready to share.
Mr. Chair and members, I believe this is to Senator Limmer's amendment. So at line 3.25, page 3, line 25, before, within, insert, a parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data, period.
If you would repeat that one more time, please.
Yes, Mr. Chair and members, page 3, line 25, before, within, insert, a parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data, period.
Mr. Chair, I like that.
Senator Limmer,
Mr. Chair, I move the amendment as expressed by council.
Senator Limmer moves the oral amendment as read by council. Senator Bigham.
Mr. Chair, I'd like that. I agree with that. Thank you, Senator Limmer.
Mr. Chair,
Senator Anderson.
would you reread the amendment for us?
Yes, we'll reread it again.
Mr. Chair and members, page 3, line 25, before within, insert, a parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data.
Senator Latz.
Mr. Chairman, I think this is a good way to create the substantive right, which would fix what I perceive to be a drafting problem with the bill. I think it's still a separate question, how clearly we apply that opt-out provision and the if applicable aspect of it. And frankly, one of my questions may be whether or not we need to have an applicability provision in the substantive right itself. Otherwise, it becomes an absolute 100% right to opt out of everything. It says any program or activity that allows a technology provider access to student educational data. Is educational data defined somewhere else? That's at the beginning of the bill, I think, or?
Ms. Primo.
Mr. Chair and members, you'll find the definition at the beginning of the bill. And please note that pursuant to the A2 amendment, none of the changes you see at the beginning of the bill are being made. So that would be a current law definition. The amendment reinstated the stricken language and deleted the new language.
Which relates to a student. Well, Mr. Chairman?
Senator Latz.
I'm just glancing through the definition, but that appears to be really, really broad. So, I don't know, is our school bus routes, or kids that are on school bus routes, is that considered to be educational data under here? Some of the other things that Ms. Doslin testified would be really hard for a district to create opt-outs for. Are they included in here? I mean, maybe this is where sort of the rubber hits the road. It's where we define what is opt-outable. And I think we probably need to do that in the in the substantive right here as well. Otherwise, we run into some of the same vagueness issues that we did in the notice provision, the if applicable part.
Mr. Chair.
Ms. Dozland.
Thank you. In regards to the question about the if applicable, I had mentioned that we had suggested language in the past over in the other body that shall not be named, but and what we had suggested on lines 4.1 or thereabouts was to just say something along the lines that the include information about the contract and inspection, and if applicable, the parent or student's ability to opt out of any program or activity, that allows a curriculum testing or assessment technology provider to access the student's educational data when the program or activity is not essential for schools to maintain instruction or operations.
Would you repeat that last line
Certainly.
part again?
To access a student's educational data when the program or activity is not essential for schools to maintain instruction and operations.
All right, thank you.
Thank you.
Mr. Chair.
Senator Limmer.
Mr. Chair, aren't we getting into the same problem of vagueness when it refers to not essential for schools to maintain?
Yep.
I think that just trades one
Exactly.
vagueness for what we're proposing.
Correct.
And I guess I can see why the other body may have rejected it. So I don't know if that necessarily solves it.
All right, thank you. Senator Latz.
Mr. Chairman, I would agree with Senator Limmer that it is still a bit vague, but it seems to me a little more narrowly framed scope. If applicable, provides almost no guidance whatsoever. Essential provides, I think, a little more guidance. Unless we were to get into specific databases or activities, if the parties could agree that there are certain databases or activities that should be exempt or opt-outable, or not opt-outable, I guess really is, that would be great. We could put a list in there that's, on the other hand, I think the provision, probably more important to protect student data, to say that any provision in a contract with a tech data provider that allows the data to be commercialized in any way is void as a matter of public policy and is invalid in the contract or something like that. In addition to the flat-out prohibition that's in here. I mean, that's probably the most important feature of this. So, I don't know, I guess I like the language proposed by Ms. Dozland better than I like sort of the if applicable language, which seems to have, the only guardrails are the eyes of the beholder.
Mr. Chairman?
Senator Limmer.
Have we strayed off the language that council gave on the substantive right? Or are we still on that?
We haven't voted on that yet, have we?
Well, Mr. Chairman,
Senator Latz.
I think we need to address this together with that language, because I don't think we can create a substantive right that may be different than what's in the notice about the substantive right. So I think we need to get our arms around what is the substantive right in the first place, what opt-outs are allowed, what aren't allowed. And then the next step is they must give the notice of the right to opt out described in paragraph H.
Mr. Chair,
Ms. Decker?
just at the risk of extending this wordsmithing, I think if we start getting into listing things for the opt-out, we risk making this bill something that is frozen in time and isn't able to move with technology as it continues to develop.
Mr. Chair, one other thing.
Senator Bigham.
Who gets to define what essential is? I mean, Senator Limmer's correct.
Senator Latz.
Mr. Chairman, who gets to define what if applicable is?
Mr. Chair, I already did. I already explained what it was.
Senator Bigham.
Then I'm
Senator
sorry, I
Latz.
missed that explanation. Then could I maybe hear it again?
Senator
So-
Bigham.
Thank you, Mr. Chair. So if it's a software application, like I said, that would show your daughter's schedule, who her teachers were, the grades and all of that. It isn't, it's applicable. That's good, that's fine. If it's been doing this all day. Because you can't have an alternative way of doing it, that is fine. It's applicable because it's the only use that can provide that service.
So are you trying to draw a distinction maybe between something administrative like a bus schedule or an attendance record or something versus an actual curriculum that there would be multiple versions of, and you're trying to not let the administrative piece where everybody's gonna be run
Correct.
through this electronic record confused with some curriculum piece
Correct.
where there might be multiple options.
Correct, much more articulate than I am. Yes, Mr. Chair.
So, Mr.
Senator
Chairman,
Latz.
as we're spinning hypothetical, more descriptive language about what if applicable means, why don't we just put that more descriptive language in here instead of saying if applicable? If it means its only use that can provide that service, then let's say that. That sounds pretty close to essential to me, actually. But let's just say that instead of if applicable. If it's some other definition, as Senator Bigham is providing us with some thoughts on what kinds of services are, curriculum, non-curriculum, whatever, let's say that.
Is there a student data privacy concern outside of curriculum? Or is the whole reason for this bill in the first place solely curriculum focused?
Mr. Chair.
Ms. Decker?
It is not solely curriculum-based. I think the focus of this bill is the fact that technology providers and technology companies have become so heavily enmeshed with the government via schools, and that by virtue of that enmeshment, many of these systems allow information to be collected, maintained, disseminated by these technology providers, including some of these, very central systems. And I think I've raised this in committees before, that this technology gets ahead of us. It becomes so pervasive that it is very hard to pull back. And when we get to a point where we are trying to pull some of this back, yes, there are going to be changes that need to be made. But the fact that technology becomes so pervasive that we can then no longer protect privacy, protect civil liberties, that should not be an excuse to not at least try to make some changes.
What type of real or potential application outside of curriculum might come to your mind? Because I'm trying to think of what an example might be, and I'm coming up empty, so maybe you could help orient me as to what an example might look like that's outside of the curriculum area.
Mr. Chair.
Ms. Decker?
So there are a number of programs that have been written about pretty widely in the media that are, for example, monitoring students' behavior, monitoring web browsing. There is, as is in the bill, the ability to, flag keywords in documents, whether, if those documents are on the school-issued device. There have been some articles written about technology that can monitor voice levels to try and, decipher if somebody is agitated or their sort of temperament. So I think, again, these technologies are evolving very quickly and they're being deployed very rapidly. And I think the uses are not just specific to teaching a particular subject, but can be very widely used.
Okay, that's helpful. So Ms. Primo, after all of our ramblings, I don't know if there's a way to help make sure that we're not catching up some basic administrative functions in, because I think we'd all agree, bus routes and attendance records perhaps, we all probably don't care about. I think we all would care about online monitoring and behavior, and we'd all care about curriculum. Is there a way we can define that somehow, I think is our next question to wrestle with.
Mr. Chair and members, I don't recall where the committee left off in terms of the suggestion made by, I'm sorry, I don't recall the person's name, but the testifier who just came up. You could take what she had proposed and add it to the Senator Limmer oral amendment so that I can read it and then maybe the committee can discuss and further refine it, perhaps. So it would be line 3.25 before within, insert, a parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data where the program or activity is not essential for schools to maintain instructions or operations. And I know there was some disagreement or discussion about essential, or, you could do something where, solely for non-curriculum based activities. I'm just throwing these out there, Mr. Chair.
Repeat the new part of that line again, please.
Sure. So at the end of the previous sentence where, I'll just read the whole sentence. A parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data where the program or activity is not essential for schools to maintain instructions or operations.
Senator Limmer.
Did we, I guess the question would be is, did we satisfy the vagueness issue?
Mr. Chair,
Senator Bigham.
to add to that vagueness, what isn't, in instructional or operational that we? So I don't, again, that's why getting more explicit was difficult to accept. And so, because I think you're gonna, as you originally said, Senator Limmer, that it's like you're changing one thing for the other. That's why the straight opt-out, if applicable, is honestly we're saying this all on the record, so when it comes into question at any further down the road, they're gonna know our intent. It is like what Chair Matthews said, we don't care about the attendance records, we don't care about the schedule, who the teacher is and all of that. We care about you know, collecting data on searches and on other things that Ms. Decker brought up, so that that can't be disseminated for commercial use. So I understand, I like your First Amendment, but the addition is a problem because it still brings that vagueness into there. I would prefer that we adopt your First Amendment. But
And that is technically still what is before the committee. It was just the first sentence that ended at student education data. The most recent language has not yet been moved or incorporated into your oral amendment.
Mr. Chairman, why don't we take this in steps? Let's move the first part that council expressed. And then we can keep talking.
So, Ms. Primo, why don't you read the motion before us, hopefully one final time.
Mr. Chair and members, page 3, line 25, before within, insert a parent or student must be provided an opportunity to opt out of any program or activity that allows a technology provider to access a student's educational data, period.
Is there any last discussion to that specific oral amendment? Senator Latz.
Is it Senator Limmer's intent then for us to further consider the additional language?
Senator Limmer.
Yeah, Senator Latz, yeah, I don't have any problem with continuing to discuss and even consider other options, but I thought we'd at least get this into an amended form that would be accepted into this. And, you know, if we still have concerns about other elements in the bill, we should probably keep talking.
So,
Senator Latz.
Mr. Chairman, I'm going to support this amendment just from a process standpoint, so we can get something on paper that we could then consider amending with the essential language or some other language to bring further clarity to it. So I think just so we can kind of keep track of things, might be easier to put this in and move from there.
All right. Any other discussion to the oral amendment before us? Seeing none, all those in favor of the oral amendment as read by council, say aye.
Aye.
Aye. Opposed, say no. The oral amendment is adopted. Who's next? Senator Carlson, you've been waiting very patiently.
Thank you, Mr. Chair. And I have even more questions now than I had before. One of the things that has bothered me is this applicability, and I'm not sure if I understand the definition where we talked about a system that's already in use, and whether you can opt out of that system that's already in use if there's no paper alternative. And I guess to go back to what I was thinking is that, you know, if we're talking about teachers using digital curriculum today, would they have to stop that and put in on paper curriculum? Is that the only alternative they have if somebody wants to opt out? Or is that one of those that you can't opt out? Also, how about the school management systems like grades, transcripts, GPA calculations and reports, class ranks, course scheduling? And then what we have also is in Minnesota, you have to report special education data to the Department of Education, that's all digital. And can a person opt out of that? This is where I'm not really sure if I understand what things you can opt out of, and if you opt out, what is going to be replaced by opting out of that system.
Senator Bigham.
Mr. Chair, Senator Carlson, this was earlier on. So if it's in a software where it's general stuff like attendance, bus stuff, bus routes, your schedule, who your teacher is, all that, that is not what we're concerned about. So this bill would not impact that. It would be fine. So that's not the concern.
So, Mr. Chair.
Senator Carlson.
Just to be clarified, so that would not apply to any curriculum that is already digital?
Mr. Chair,
Senator Bigham.
Senator Carlson, what I just mentioned was not curriculum.
Okay.
That was administrative. So that's not gonna be impacted by this bill because it wouldn't be, it's, you couldn't do it another way. I mean, so that's why it wouldn't be impacted by the bill. So that's administrative stuff, like we've said.
Okay, to borrow a phrase.
Senator
Mr. Chair,
Carlson.
to borrow a phrase from your testifier there, we would be freezing education in time if we did not allow new systems to be adopted, and we'd allow people to opt out of present systems so that you could not go totally digital. Am I understanding that correctly? And I guess I'd like to hear from some of our testifiers and see whether I'm on the right track here, that we would have things that we would be opting out of, that we would have to initiate some kind of other alternative system. And the reason that I say that is I've had many emails on this bill that say exactly that. And I don't know, these are from technology people in schools.
Mr. Liddell online has his hand up. Why don't we go to you first? Mr. Liddell.
Thank you, Chair Matthews. And Senator Carlson, to address your concerns, speaking from the parent's perspective, in some cases, yes, it is appropriate, and it's not necessarily a step back to be moving away from all digital instruction. There's a lot of things that do not have to be consumed via a tablet, via a digital textbook. And all of the science, well, the vast majority of the science, kind of to a level of consensus approaching climate change, is that learning with paper is more effective for kids learning, and it's better for their retention and ability to understand the subject matter. So you don't necessarily have to learn math on a computer or learn English on a computer or read a book on a tablet. There are a lot of things that you can do in other ways, and we still have books, we still have newspapers. I've got one sitting here next to me. And I'm a fairly young father with young kids at home, and so I would urge this committee to resist the narrative of technological inevitability, and that doing it on a computer equals progress. Of course, there are things that need to be done on a computer. Learning how to code, for example, is chief among them. Word processing, graphic design, all of those things. But it does seem like a lot of this was implemented for good reasons, or certainly understandable reasons, around administrative cost savings and efficiency, without really consulting parents or kids or pediatricians, people who have other views on the health and well-being of young people. And so in some cases, as I read this bill, it may indeed require that alternative methods of instruction be required, but I would disagree that that's necessarily a step back.
Senator Carlson.
Thank you, Mr. Chair, but I guess I'm going to have to push back on that statement. Here we are, one of the few times that we've come into this room to work, and prior to this, we've been on our computers for almost 2 years. Many people are now working from home on their computers. They don't have to deal with paper anymore. And actually in our schools, we're trying to get young people to work on computers even more. When they get into the work world, that's what's going to be expected of them. And so to deny that, and I will say that if we have to have a paper alternative to something that's digital, which you are saying, which I don't think this bill is trying to say, that is a stoppage. That's If you want to prevent somebody from stealing your horse, you break the horse's legs, instead of trying to figure out how to stop this theft of information. We've got a theft of information here that we're trying to deal with, and I think that's what we should be dealing with. We shouldn't be dealing with trying to stop the young people from being educated. So, thank you, Mr. Chair.
Respectfully, Senator.
Mr. Liddell.
Thank you, Chair Matthews. Certainly no one from my organization or from my general worldview is trying to stop kids from being educated. This is an issue that affects education, but also a lot more. And you do mention that people have been at home on their computers for the last 2 years. Young people have been on their phones for the last decade, and we've seen youth mental health plummet over that time. I understand that is somewhat outside the ambit of this bill, but to give you the context for why I and my group are so committed to this cause, youth depression, anxiety, and suicide rates have tripled in the last 10 years. And the only causality that anyone can really get to the bottom of, all of our best researchers, leading pediatricians, has to do with the amount of time they spend on a computer. And so these are huge public policy questions with real material implications. This bill specifically gets to data, but it also does get to this idea that what is convenient and cheap for administrators takes precedence over what's good for kids. And I think it's really important to understand that, a 6-year-old child, their mind and their body is not physically meant to sit in front of a computer all day. An 18-year-old young person is not really cut out for that either. And so I would urge you all to try and keep this in a larger perspective and understand, I'm in Austin, South by Southwest this year every year. This is where the leading technologists come to talk and think about technology. And if you go to any of these sessions here at South by Southwest, what are all the people from Google and Facebook taking notes on? Paper. They have their moleskin notebooks and their pencil and paper out, because for them, that's the most effective way to learn and absorb information. And if it's good enough for those adults, and if that's what those adults need in order to learn and understand, then I think it's certainly worth considering that's what young people need as well.
Thank you. And
Mr. Chair, I need to respond there.
Senator Carlson, I do also want to make sure we stay on the topic of the bill too.
That's what we're doing, is we're gone way off topic here. Way off topic. And I just want to tell the testifier here, my son works for Facebook, and don't tell me that he uses paper. He does not.
Okay, Mr. Chair.
All right, we'll go back to the topic of the bill. I believe council has another suggestion that I will ask you to entertain for us. Ms. Primo.
Mr. Chair and members, so the proposed language would be, again, at line 3.25, before within, insert, the right to opt out does not apply to programs or activities that are essential to maintain school operations. And I'll read that one more time. The right to opt out does not apply to programs or activities that are essential to maintain school operations.
And Mr. Chair, if I could speak to the amendment,
Senator Bigham.
because I'll be moving it at the end of it. This gets to the core issue that I have not been able to articulate, because I keep getting tripped up on the word applicable, which is ironic, isn't it? And this handles what you, Mr. Chair, brought up as well, that we don't care about the administrative side of this, the bus routes, the attendance records, and who's your kid's teacher and your schedule and all of that. So this narrowly brings that in. So I would move the amendment, the oral amendment.
Senator Bigham moves the oral amendment as read by council. Ms. Primo.
Mr. Chair and members, I'm sorry, but can I also have a direction to make technical corrections and correct internal references.
Yes, that is
Senator
part of the
Bigham-
motion.
Senator Bigham agrees to incorporate that into her amendment. Senator Latz.
Mr. Chairman, I know one difference between the language that was earlier proposed with the proposed amendment here, which is that it leaves out reference to instruction. So I wonder if that was intentional. And the language I had before was where the program or activity is not essential for schools to maintain instruction or operations. And this one just says to maintain school operations.
Mr. Chair.
Maybe I could get some feedback on that.
Senator Bigham.
Yes, it was intentional.
Okay.
Senator Latz.
Mr. Chairman, I'd be interested in the position of the school administrators and school boards and those groups that Ms. Dosland represents as to the proposed amendment.
Ms. Dosland.
Thank you, Mr. Chair, members of the committee. It is important that we include the words instruction as well, because as was discussed a little bit throughout the night, there are school districts that are switching completely to the use of digital curriculum instead of textbooks. There's examples in St. Paul. I think Mr. Patternus and Osseo can talk about what Osseo is doing. And yes, there's parents can opt out of curriculum, and that would still be in law. We just, if they don't want to use the technological device for the delivering of the instruction, that would be very problematic if they opted out of that. And maybe Mr. Patternus can explain a little further.
Senator Latz.
I'd be interested in Mr. Paternos's explanation.
Mr. Patternus, are you still with us?
I am. Thank you, Chair. Yeah, when we think about operations, I think that really defines the concerns that we had in terms of a student information system, transportation systems, those things that are logistics for ensuring that we function. What is not clear, and I think the importance of the instruction is as Valerie said, we have got a lot of curriculum that we're moving towards with really only digital resources. Minnesota history was one of those curriculum examples that I mentioned earlier. As we've moved into new math curriculum within our system in Osseo, that is all in a digital format for students to access the content and manipulatives. And as we look at curriculum as we move forward, it's a lot more dynamic than your traditional textbook. As a former math teacher, and I look at these digital curriculum resources that are coming in replacement of textbooks, it offers new opportunities for students to deeply engage and manipulate with manipulatives in those spaces to understand the standards that we're trying to deliver, which is why we tend to move in those directions. In terms of if we had to provide an alternative, that's going to come at a financial burden to school districts, because essentially you're talking about a core adoption of a digital curriculum, and then also having to buy or purchase a text paper copy as well, which would potentially double the costs of any curriculum adoption in a district, which often comes at the cost of millions of dollars for a school district at any given time.
Senator Latz.
Mr. Chairman, could Senator Bigham explain why she did not include instruction in the amendment?
Senator Bigham.
Thank you, Mr. Chair. Senator Latz, it's because there are instructional apps that retain that private data on students and can disseminate it for commercial purposes, hence why we need the opt-out for that portion of it.
Senator Latz.
Mr. Chairman, do we have the ability perhaps to say that those apps can't be used if they have the right or ability to retain that digital data and disseminate it beyond what we deem to be acceptable? Why don't we just say, can't use those apps, or those apps have to change? I suspect those apps will change if they want to be used in the schools.
And that kind of goes to the crux of a question I was considering, because I agree with Senator Bigham on this one about intentionally leaving out the word instruction. However, I've also been considering that I think our discussions here are talking about the only two options being a digital format or a paper format. And I could easily foresee where instead the two options are a digital format that collects a lot of data that a parent might not like that particular one and instead wants that replaced with another digital platform that does not collect so much data. So while our discussion is centered around digital or paper, there may be circumstances where those aren't the two options that we're going between. Senator Latz.
So, Mr. Chairman, would you be more comfortable if we said something that these instructional apps or curriculum apps are not allowed to utilize or disseminate this data for purposes unrelated to provision of the curriculum to the students? Period, flat out?
I think that's what the language of the bill is
Yeah,
here trying to do.
Mr. Chair, Senator Latz, that's the bill.
Well, if that's the case, then why are we concerned about not including instruction in this here? It sounds like that problem is solved. So we could include instruction in the non-opt-out category because, you know, the other part of the bill, we're circumscribing their use of the data
Mr. Chair.
without creating the administrative problems that would be caused if someone could opt out of an all-digital curriculum.
Senator Bigham.
Because should still be able to opt out of it. I mean, if there are, as Chair Matthews just said, if there's one or two apps, and one does retain and one and disseminates or whatever, you have to be able to opt out of that to go into the one that doesn't. So that's why you need the opt-out side of it. And I think this tightens the amendment that I moved, tightens that up to help alleviate that administrative side of the equation.
Mr. Chairman.
Senator Latz.
I'm sorry, but that reasoning is completely circular. If the bill already says they can't disseminate the data, the apps can't disseminate the data, then what's the concern about keeping students in that curriculum? I mean, that's the whole point. If the choice is an app that disseminates data and an app that doesn't disseminate data, there's no difference because the bill already says you can't disseminate the data, period. So I don't care what the app's capabilities are. If they can't do it, they can't do it. Or they're breaking the law anyway. We ought to make sure there's some kind of penalty provision probably as well.
Mr. Chair, there is one other thing.
Senator Bigham.
Things, I mean, there are some people that just don't want the data disseminated at all. And so that, the opt-out, regardless of how many iterations of the app there are, I mean, there is that side of it too. It's just people don't want their kids' data retained at all in an app. So, again, the amendment that I put forward handles the administrative side of this equation.
I think I'm also asking your same question, but from the other side. If instruction is in the rest of this bill, then what would the reasoning be for insisting that instructions included one more time in a new line? It cuts both ways. Senator Latz.
I think the response to that would be the administrative difficulty of having a student opt out of a particular instructional app and thereby obligating the school to provide some alternative instructional app that either doesn't retain the data or isn't digital at all. Then you could have multiple students creating multiple administrative burdens on the schools to come up with alternative apps that meet their own criteria. and it would be the school's duty to find something that they would provide it, maybe even a substandard educational quality. And then you get into a whole nother morass. All right, I opted out of this app because I don't want them to retain my students' data. But school, you better provide me with an absolutely equal and equivalent educational experience. So find another app that does the same thing, is just as high a quality, but doesn't retain the data. And if it's not out there, what's the school to do? I mean, do you end up with a school using 3, 4, 5 platforms, including a non-digital platform, to provide a particular curriculum? How does a teacher handle that? Or a book. But I can tell you that my daughter's use of her iPad in math is a much more effective way for her to learn math than just on a piece of paper. She can work through the problems, she can cross off very quickly, she can put in alternative options, she can jump around between programs that give her guidance or instruction or illustrations and then go back to the problem and plug in alternatives to try to figure that out, which was much, much harder and less effective probably when I was a student. And it's only going to get better. I guess, as Mr. Patternus said, you can more deeply engage in some of these digital tools to learn the curriculum than we ever could when we were in 8th grade. And I don't have any problem circumscribing the use of the data. And if it's a question of people not wanting their data to be, kept at all, well, then I guess they can opt for an all non-digital lifestyle. But I don't think we can expect our schools to accommodate that anymore.
Mr. Chair,
Senator Bigham.
I would say that if there are multiple people, and in this case, we're saying parents, right, are going to be opting out on behalf of their students, then that school has a problem with the software company and probably would be looking at a different software company. This idea that parents would all of a sudden, multiple parents would be opting out, that's indicative of a larger problem for that software company. So again, I would just say that there are people that don't want the information retained at all and that data retained at all. And there shouldn't be a choice of going to school or not going to a public school because your data is going to be retained. I don't think that that's what we want. So, I mean, we ought to be protecting this data. I think this amendment is a good effort at stopping the administrative side of that equation in what we are caring about in protecting the data. And as for the instructional side, I think it's definitely still applies in the bill. So I would ask that we move to a vote on the amendment.
So, Mr. Chairman?
Senator Latz.
How does it work if a student does work on a math section 2 out of 8 in that quarter? And when they're done with their worksheets, the data gets dumped by the app provider because they're not allowed to retain the data. And then they get to section 8, they get to the end of the quarter, they want to go back and review their work. But the data is no longer retained. What are they supposed to do? And what does retaining the data mean? Can they do the worksheet once and then have it dumped? Can they do the worksheet twice before the data is dumped? Do they wait until after there's been a subject matter test in that subject before all the worksheet data is dumped? Or is the data going to be there for them to go back and study off of for the test? I mean, what does retained mean? I mean, is this the kind of data we're talking about? Is there answers on the worksheets or I mean, I don't know how that works. I know my daughter does. When it's time to study for her vocabulary quiz, and the test is not only on the first two sections, and then the second two sections, and the third two sections, but as you get to the 10th week, her instructor is having the test on all of the sections that came before it, in addition to the two new sections that they've learned. Can the app save the data for those 10 weeks so she can go back and study off of what she had inputted before? Or is the app company going to be required to dump it at some point in the process? So it's not there anymore for her to go back to.
Yeah, I don't think that type of hypothetical has been what has been under discussion this evening. I don't think we're asking about whether students should have, the data dumped or cleansed week by week. I think it's identifying whether there's a particular company that's using it for a commercial purpose, probably at the end of the semester or a year or two down the line or something. I don't think that anyone's here with the goal of having them erase data off a problem quickly after, so that it wouldn't make sense if that's a digital program you're using to delete as you go, so you can't rely on the beginning work as you're studying for your end or final test.
Well, but Mr. Chairman, you may be very right, but I heard Senator Bigham say there are parents who object to data being retained at all, period. And I don't know what that means.
Mr. Chair,
Senator Bigham.
if you opted out of it, out of this, you would not be retaining data because there'd be no data to be retained if you opted out. And there are parents that don't want their kids' information retained, inserted, inputted into these apps, period. So there'd be, Senator Matthews is right, but more importantly, it's that if you opt out of this, there's no data to be put into it to retain. And there are parents that don't want that.
Someone at that level would probably be going back to the old-fashioned thick math textbook and then
Might even have a chalkboard. I don't even know if you're old enough to remember chalkboards, Mr. Chair.
I use the notebooks, and my parents talked about how I'd go through as a young kid. Suddenly, the one area we'd be concerned about saving paper was when we were trying to learn to show our work in the math problem and take the whole page if we had to.
Well, Mr. Chairman,
Senator Latz.
if parents want a student to completely opt out of a digital education, I guess that's their right. And I'll be candid, they probably ought to be homeschooled, because I don't see how our school districts are going to be able to accommodate an entirely digital student curriculum. I'm not sure I would want to require them to do that. But I don't know, I guess I'd be interested whether or not our educational administrators are comfortable with the notion of not including instruction in this. I think instruction, I think we ought not to be able to opt out of that instruction. But that's just my view.
So they did.
Formulating tonight as we discuss all this.
Yeah. Senator Limmer.
Thank you, Mr. Chairman. I'm listening to this, and I'm kind of wondering if maybe our education system has gone too far into the high-tech range. Simply because are we with high-tech, are we truly satisfying the constitutional requirement to provide a proper and equal education to every child if you have to have a computer to get the education? And then using a computer that could be tracking the student on other things that they plink around on that same instrument. And so I'm just putting that out there. I'm wondering if the tech age has brought us too far, too fast. And now, are we truly satisfying that opportunity? And simply because you don't want to use a computer or you're fearful of the computer tracking you, some might say, well, then they should be homeschooled. I'm just not sure if that's the proper opportunity we as a state want to provide our kids. So I'm just putting that out that maybe our discussion is getting a little far afield of what's before us.
We should try to get back to what's before us and to the amendment before us, and I think we do have some differing opinions on this subject. I think I like and support the amendment as it's been explained out by counsel, and I know we've vigorously debated that, and I appreciate all the points that have been made on the respective sides, but that's my view on it right now at this point. Senator Latz.
I don't want to unnecessarily prolong this, but I'm just kind of thinking this through. Does maintain instruction mean, if we were to insert maintain instruction, does that include curricula, or does it not include curricula? Is there some basket of operations around maintaining instruction that are not curricula related?
Well, instruction's not in the proposed amendment. I think that's been the crux of this last discussion of putting it in or not.
I understand that, but it was proposed, Mr. Chairman, as an option, and so maybe I'm asking a question of Ms. Doseland, whether or not their contemplation of the term maintaining instruction included curriculum. Did they not want students to be able to opt out of digital provision of curriculum? Or did they seem to think that part's okay, they'll provide the paper curriculum if necessary?
Ms. Doseland, could you be brief in an answer to that point, if possible?
Thank you, Mr. Chair, and I actually would ask if Mr. Patternus could answer that question.
Mr. Patternus?
Thank you, Chair. Yes, we see the addition of instruction to be curriculum in terms of the format of the curriculum provided. So when we think about opt-out of curriculum right now, we do have provisions in state law that allow families to do that, but they don't necessarily opt out of an entire textbook. They opt out of a section of curriculum within that text or curriculum that's provided within that class. So the concern that we have with not having instruction in there is it provides the lens when we have an all digital textbook that now we're removing that entire digital text from the student, not just necessarily a portion of curriculum that they wanted to be opt out of like they can right now in state statute.
Mr. Chair.
Senator Bigham.
I also would say, similar to that, I don't think every parent would opt out of every application necessarily, right? It might just be one that there's a concern with or that it's been reported they are disseminating the information. The other thing I would say, and there's a reason it's in there, is the notice period that somebody has to give to opt out is meant to be useful and helpful to the school districts.
Are we prepared to vote on the oral amendment? Senator Latz?
I'm going to offer an amendment to the oral amendment. And the amendment is after the word school, insert instruction or. Well, we'll see for.
Senator Latz offers an amendment to the oral amendment.
Well, here, let me think about it.
Senator Latz.
Because this is written a little bit differently than the earlier version of the language I was referring to. Yeah, so it would say the right to opt out does not apply to programs or activities that are essential to maintain school instruction or operations. So my oral amendment would be to insert instruction or after school.
Ms. Primo, if you would clarify that or reread that for us.
So Mr. Chair, members, Senator Latz's oral amendment to the amendment, to Senator
Bigham's.
Senator Bigham's oral amendment is after school, insert instructions or.
Senator Bigham.
Mr. Chair, I would oppose the amendment. As I previously said, there are apps that are for instructional purposes that do retain and disseminate the information, and I believe that it should be an opt-out for parents to have the right to decide that. There's notice, and just gonna continue to say that because that's the crux of the bill.
Mr. Chairman?
Senator Latz.
First of all, those apps that are disseminating information will not be allowed to do that anyway, because there's another provision in the bill that says they can't do it. That's the crux of the bill, apparently. So including instruction in here will not have any impact on that provision. I don't think it's accurate to say that you're undermining the crux of the bill if you insert instruction. Secondly, I'm informed that the school administrator groups that are represented by Ms. Doslin, the elected school boards and the school administrators and the associations of school districts and so on, metropolitan school districts, the statewide school districts folks, that if instruction is added, that they will be neutral on the bill going forward. I think there's some value to having some stakeholder agreement on a bill like this, too. So I would encourage a yes vote on it. Thank you, Mr. Chairman.
Members, any discussion? We have the Latz oral amendment to the Bigham oral amendment. And though I get your point too, I know what the intent is, but I think I'm with Senator Bigham on this one. And I'm not sure why these words being included here is what's the crux between the school boards being neutral versus not. A lot rolling around in my mind, so I understand it and I appreciate it. It feels like we're coming at the same coin from the opposite sides. You're asking if it's no big deal, why not have it in? And I and Senator Bigham seem to say if it's no big deal, let's just leave it out. But
Well, Mr. Chairman, it does seem to be a pretty big deal to an awful lot of people that are involved in teaching our students, in running the entire administrative structure that teaches our students. And I think I get a sense of it, but I'm not in their shoes, so I'm trying to understand that here today too. But those groups seem to be speaking with a unified voice on that particular point. I'm prepared to respect that today, and the analysis I find persuasive, but even if I didn't, that's a group that on this issue I'm willing to defer to.
any further discussion? Seeing none, we'll vote on the Latz oral amendment to the Bigham oral amendment first. Is everyone clear on it, or do we want council to read it one more time? All right, everyone seems to be clear on it. All those in favor of the Latz oral amendment to the amendment, say aye. Aye. Opposed, say no. No. In my judgment, the oral amendment to the amendment does not prevail.
I'll
I'll renew my amendment, my motion for my amendment.
Senator Bigham has the oral amendment as originally read by council. Any final discussion on it? Seeing none, all those in favor of the Bigham oral amendment say aye.
Aye.
Opposed, say no. The oral amendment is adopted.
Mr. Chair,
Senator Bigham.
I would move that Senate File 2307 as amended be recommended to pass and sent to the Education Committee.
Let me verify that everyone else, there's no further questions from the committee. Senator Latz.
With those amendments added, I'd like to ask council whether we need to make any changes to the notice provision that's contained on line 4.1 and the following provisions.
Can you repeat line 4 point, what are you pointing?
4.1, where it has that if applicable language, for example. Just wondering if some of that language now is inconsistent with the substantive right to opt out that we just adopted.
When you're ready, Ms. Primo.
Mr. Chair and members, no, I do not believe it has to be changed. Now I would read, if applicable, to essentially refer back to the two amendments read together. So, you know, it would not be applicable to maintain school operations. But it would be applicable in, you know, any other settings. I think that's how I would read that provision with the new language.
Senator Latz.
Mr. Chairman, I think what I would suggest is that we do something like delete if applicable on line 4.1 and on line 4.2 after opt-out, insert under the provisions of paragraph H.
Ms. Primo.
Mr. Chair and members, can Senator Latz please repeat that, just so I can write it?
Senator Latz, state that one more time.
Line 4.1, after the word and, delete comma if applicable. And on line 4.2, after opt-out, insert under paragraph H.
Mr. Chair.
I'm going to let Ms. Primo figure out what the language should be first. Senator Latz is making an oral amendment. Ms. Primo.
Mr. Chair and members, I'll just repeat it for everyone's, just to make sure we're all on the same page. So page 4, line 1, delete comma, if applicable, comma, page 4, line 2, after opt out, insert under paragraph H.
Senator Latz, is that your oral amendment?
Yes, Mr. Chairman.
And paragraph H refers back
The
to
amendment.
what we just orally amended on page 3,
Yeah.
correct, Ms. Primo?
Mr. Chair and members, it does, and then it will with the technical corrections. My plan was to make those two new provision sentences, paragraph H, and then make the current paragraph H, whatever letter comes after H, I, and re-letter
Okay.
that whole section, so Senator Latz's amendment will, is in line with those coming changes as well.
So your oral amendment is to refer back to the new oral amendment language previously, Senator Latz.
Yeah.
Okay.
Mr.
Bigham.
Mr. Chair, so just so that I understand this, and again, we've been here all day. It's it's getting late, so like you said, a lot going on up here. My understanding is that the opt-out will only, and I'm gonna use the word apply again, apply to the amendment we just put on. So you're just clearing it up and tightening up the language on that.
That's how I read Senator Latz's oral amendment. Senator Latz, do you agree?
Mr. Chairman, that's what I'm attempting to do. I guess I'd like some input. If there are any stakeholders that feel that that would complicate matters or have a different application.
Mr. Chair, I don't think it complicates it. It
Senator
actually
Brigham.
makes more sense because it's getting rid of the word if applicable, which has been not only hanging me up all night, but the committee. So I think it streamlines it. I'm fine with it. It's making a good bill better, Mr. Chair.
You're getting the full civil law experience here tonight, Senator Bigham. Something to remember
I
us
actually
by.
didn't think Senator Latz was serious when he opened his comments with saying this was going to be my last time before the committee, so we should, give her the full experience here.
Mr. Chairman, I wasn't serious at the
Senator
time, but then I listened to all the testimony and I had some questions.
Could have fooled me, Senator Latz.
Ms. Dosland.
Thank you, Mr. Chair. Without the inclusion of the word that Senator Latz had originally tried to amend onto the amendment, which was instruction, we continue to have concerns. We would have hoped that the word instruction could have been added to the amendment. But I understand with the language that Senator Latz is proposing for the amendment, that does get at what I think the the author of the amendment intended. But we continue to have concerns because of now the bill only allows an opt-out for operations, and we continue to be concerned and want to have not to allow the opt-out for instruction.
Thank you. Any discussion to the Latz oral amendment? Mr. Liddell, if you could make your comments very brief, please. We still have two more
Yes.
bills after this one to get through, although I don't think any of them will be near this long. Mr. Liddell.
I understand. Thank you, Mr. Chairman. Briefly about why a parent might want to opt out of instruction, to give a quick tangible example. Last week, an instructional program in New York State was hacked, and all of the student data was taken. The reason that hackers are going after educational technology programs is they're usually quite poorly secured, and their parents are not monitoring for their kids' credit information. So credit cards and things can be opened up in kids' names before they turn 18. This has been happening for many years. I think it's quite reasonable for parents to say, no one is able to keep this stuff safe perfectly right now, and so I want to opt my child out for this reason.
All right, thank you. So Ms. Primo, if you would read the Latz oral amendment one last time.
Mr. Chair and members, I will, and if it's okay with the committee, I'll also just add my technical corrections to this amendment, since
The
just take care of
disclaimer,
it.
the famous disclaimer, Mr. Chair.
So, page 3, line 25, delete H, insert I. Page 4, line 1, delete comma if applicable, comma. Page 4, line 2, after out, insert under paragraph H. Page 4, line 4, delete I, insert J. Page 4, line 6, delete J, insert K. And that concludes the amendment, and there will still need to be one minor technical correction to add paragraph H to the previous amendments.
Will you incorporate that, Senator Latz? Any final discussion on that oral amendment as read by council? Seeing none, all those in favor say aye. Aye. Opposed, no. The oral amendment is adopted. Any final discussion or comments from committee members? Senator Latz?
Since the opt-out is, this would be a question, I guess, for council. On line 4.7, we make reference again to the opt-out. Do we need to refer back to paragraph H or not?
Ms. Primo?
Mr. Chair and members, I don't think it's necessary, but I also think it is fine to put in there for clarity's sake. It's really up to the committee members.
Senator Latz?
Mr. Chairman, I move on line 4.7 after the word out, insert under paragraph H.
Any objections, Senator Bigham?
I'm assuming it's just conforming to where the other spot
Same-
in the bill, so
same
no,
as we
there'd be
just
no,
did.
yeah, no.
Ms. Primo, if you'd read that for us.
Mr. Chair and members, page 4, line 7, after out, insert under paragraph H.
Any discussion to that oral amendment? Seeing none, all those in favor say aye. Aye. Opposed, no. The oral amendment is adopted. Senator Bigham, do you have any final comments?
I think I'd say final thoughts, Mr. Chair, which I'll keep to myself. Yes, first, I appreciate, thanks, Senator Limmer. Thank you to the committee for this final experience of being in the Civil Law Committee, and next year, maybe it'll be combined, so if I have to come back, it'll be just in one committee and I can get this over with. But thank you, this is a very important topic. It's really dear to parents, students, and keeping their data private and giving parents the right to have control over this, and so that information isn't disseminated for commercial use, because we don't want that. That's not a good thing, and that's not part of the education system. So with that, Mr. Chair, I appreciate the testifiers. I appreciate the stakeholders involved. And with that, I would move that Senate File 2307 as amended be recommended to pass and referred to the Education Committee.
As amended and amended
And
and
amended.
amended. Senator Bigham renews her motion. All those in favor of that motion signify by saying aye.
Aye.
Opposed, no. The motion prevails. Thank you, Senator Bigham. We have 2 bills left.
They said I did. I was going to be.
Senate File 3920, I'm going to pass the gavel to Senator Limmer. Okay. Senator Johnson.
After that last performance, this is a dangerous place to be here with the gavel. Senator Matthews, to your bill.
Thank you, Mr. Chair. I'm sure this was the bill everyone came here today to discuss. It's a bill for fraudulent business filings. It was brought to me by the Secretary of State's office, and I'm just going to let Ms. Freeman kick it off and walk through the bill for us.
Thank you, Mr. Chair and Senator Matthews. Nicole Freeman, Secretary of State's office. I'm sorry, Mr. Chair. I didn't let you cue
No,
me
no.
in. Okay,
Very
thank
good.
you.
Please continue.
All right, thank you. Well, thank you, Senator Matthews, for carrying today's bill. So most people, when you think about the Office of the Secretary of State, they think about elections, as we are the chief election administrator in the state. However, what most folks don't realize is that most of my colleagues work in our business services division. They process various business filings, do apostilles, and other work there. And that work is what brings me here today to talk to you about Senate File 3920. So the Business Services Division regularly files UCC liens. These are legal notices that are filed with the office where the filer has a financial or a business interest against the debtor. The office right now acts as a filing cabinet in that we file any filing that is in proper form that comes into us after we carefully redact any 9-digit number to get rid of any potential Social Security numbers. Now, this sort of filing cabinet method wouldn't be a problem, except we frequently receive fraudulent business filings. And so this is what we're trying to solve with the bill. Frequently, these filings come in different forms, but have common characteristics that make them really easy to point out. They're retaliatory or harassment in nature, and are most commonly filed against public officials, correction officers, law enforcement, and judges. There's also something called a straw man filing that has to do with the sovereign citizen movement, where the sovereign citizens feel that the federal government has set up a straw man account at the Treasury Department. And this all sounds a little silly, but we've been in conversations with the FBI where these filings are the basis of some sovereign citizens' future fraud relating to mortgage and other retaliatory harassment filings. So the FBI is also engaged with us on these filings. So right now, our office received, when our office receives clearly fraudulent business filings, we don't have any authority to use discretion to reject the filings at the time of filing or after the fact. And so, a private citizen, if they were to discover that they had a filing against them, they would need to either be actively looking in our business database, business services database, or they would most likely be going to buy a home and their house get close to the closing process or making another large purchase, and then they learn about this lien. So if a private citizen discovered this, they'd have to retain a lawyer, go to court, and get the filing removed because there's no other process for us to do. So this bill gives us the discretion to set clearly fraudulent filings aside. And then in the event that someone believes their filing was improperly rejected, there'd be a process to appeal that decision. Alternatively, if we miss a filing that was fraudulent, there's a process that someone can go through to have the office remove the filing. This bill is a version of a pre-filing remedy that's used in 24 other states. And since all these other states have these pre-filing remedies now, we've seen since then an uptick in fraudulent filings coming to us from other states. So the office would really like to cut down on this fraud, not just for the efficiency of our office, but also for the victims. We want to relieve the burden for everyday citizens, and that's precisely what this bill does. It won't get rid of all fraudulent filings, but will greatly reduce them and really impact people's lives in a real way. Also on the, available virtually is Trudy O'Morrow, our UCC supervisor, if there are technical questions. And then we have one other testifier, a county attorney, Zender Fisher, who could briefly give some testimony too about her experience with these filings.
Thank you very much.
You're welcome.
I'm just studying up a little bit more on the bill here, but
Understandable.
we will move on to Zender Fisher.
Her first name is Michelle.
Okay, thank you.
Thank you, Mr. Chair and members of the committee for the opportunity to appear this evening to support this bill. As indicated, my name is Michelle Zender-Fisher, and I come before you today to urge support of this bill as a private citizen, as county attorney, as the president-elect for MCAA, and to give voice to private citizens who have experienced fraudulent UCC filing statements being filed against them. Currently, anyone can file a UCC financing statement against another person, thus in simple terms, creating a lien against their property. No notice is required to the identified debtor, and the Secretary of State's office currently does not have the authority to reject obviously fraudulent or bogus liens. While the vast majority of the Secretary of State's filings are proper, there are those individuals who file a statement for fraudulent purposes and for the sole purpose of harassing and intimidating individuals. Who are these individuals in my experience? They are individuals who can be criminal defendants who file fraudulent liens against prosecutors, law enforcement, and judges. They can be individuals who have disagreements with public officials such as county administrators, county commissioners, state officials, and city officials. These are individuals as well who just simply have disagreements with private individuals. In each scenario, the simple payment of a filing fee allows these individuals to file a financing statement against another person without having a valid claim or even notice to the affected individuals, creating a cascade of potential personal issues, all done for the purposes of intimidation and harassment. I offer you the following real-life example. An individual has filed fraudulent UCC financing statements against private officials, county officials in at least 2 counties, city officials, and state officials as a result of a family law matter commenced long ago. In each instance, he has filed the UCC financial statements against individuals he perceives as having wronged him or thwarted his actions to file fraudulent documents. He first started in Olmstead County against county and judicial system officials. He next moved to Nicollet County to file against county-owned property before targeting the individual properties of county officials, including commissioners, myself, and the county administrator. After those UC financing statements were expunged, he then targeted state officials and again filed against individual Nicollet County officials. His targeting expanded to city officials who after they took action in their official capacities when a citizen felt threatened by his actions toward her. He also targeted the person who filed the complaint. In each instance, public resources had to be expended by the government entities to expunge the financing statement on behalf of the public officials. Resources by the courts were needed to expunge the records, and resources then by the Secretary of State's office to act on that expungement. This takes away from other tasks and resources. Because the current statute requires the Secretary of State's office to accept continued filings by this individual, I must now conduct a monthly search of the Secretary of State's UCC filing database on an ever-growing list of people to ensure no new filings occurred. That search has to be conducted by entering the name of each individual targeted, as there is no way to simply look up the filer's name. This legislation would change that so the Secretary of State's office can reject further filings. The public officials have legal counsel available, whether it be through the county attorney's office, the attorney general's office, or other counsel to take steps needed to expunge these liens. Private individuals do not have this resource. The individual that I just outlined has filed liens against 4 individual families. These families have to retain legal counsel to file paperwork with Ramsey County District Court to expunge the liens. It is time, money, and emotional distress for these individuals, all because of the perpetual filings of this individual. I've lost count of the number of liens this individual has filed, at least 5 series of liens in Nicollet County alone. I say series of liens because each instance has involved more than one lien. He is just one person. In another example that I'm aware of, a criminal defendant has taken to filing financing liens against any judge that handles a file involving him. I believe he has filed against at least 4 different judges, but it could be more. This creates issues of recusals and amounts to blatant attempts to intimidate and harass judges. The Attorney General's office must use its resources when judges are involved. These are just 2 examples, and there are many more. When these liens are filed against public officials, the actions really impact their personal financial lives involving their families. While it requires public resources to have the financing statements expunged, the additional adverse impact to their personal lives can be significant. Because there is no notice to the purported debtor, the existence of these fraudulent liens can go unidentified until real estate is being sold or other financing action is taken. In fact, that is exactly how Olmstead County learned of their liens. One of the individuals involved was going to sell his house. It can throw the financial situation of the purported debtor into chaos. That is the goal of the filings. For private individuals, it can have even greater impact. Imagine an individual who's trying to obtain financing in these volatile financial times, only to discover the fraudulent lien. The individual's financial needs must be put on hold for at least 2 months so that person can hire a lawyer, pay the attorney's fees, the paperwork can be prepared, the paperwork makes its way through the court system, and then the paperwork is sent to the Secretary of State's office to be processed. Again, a multiple waste of resources on multiple levels. The burden to the affected individuals is significant, while the action taken to file by the fraudulent filer is minimal. My apologies, it's been a long day. As outlined, the proposed bill would give the individuals I referred to the ability to challenge the filing by filing an affidavit without having an attorney. It is fundamental that the system that is being used to harass innocent people not cause further harm to these individuals by causing them to spend a lot in attorney's fees. Currently, the Secretaries of State office must sit idle in the face of known fraudulent or bogus filings. The proposed bill would also give the Secretary of State's office the ability it currently lacks to reject those obviously fraudulent or bogus filings, thus minimizing the impact on the system as a whole. Thank you, and I would stand for any questions the committee might have. Thank you.
Thank you, Ms. Senator Fisher. I appreciate that. Comments by committee? Guess we're all talked out. Senator Matthews, I do want to thank you for bringing this bill forward. I know that just across the border on the North Dakota side, a few years ago, there were some pipeline protests that went on over there, and a lot of the North Dakota officials went through a lot of the same type of activity with the UCC filings that they had over on the North Dakota side, and really got to be a real pain in the kidney for these folks. And so now when we had the pipeline issue that was going through the northern Minnesota side here, well, actually this last summer was a big part. You've had a lot of these, muleteer folks that were going around that this was a big threat for a lot of us up there in northern Minnesota. So, if they, I don't know what, drank some Busch Light or something, decide, let's go file these UCC statements. We were pretty concerned, prepared, and watching a lot of these filings on our personal side for what might actually come down at us. So I think this is something that really is needed in the state to protect people across the state from these fraudulent filings. So thank you so much for bringing this forward. So with that.
Thank you.
Senator Carlson.
Yeah, thank you, Mr. Chair. I've had a little bit of exposure to this through the St. Paul Police Department. They actually had a training session on these, the people that are doing this, because they train, and it started out in southeastern United States with the sovereign citizen movement, and they were training each other to do these filings. And what we heard was that any attorney, Senator Johnson, any attorney that someone didn't like would wind up getting a like $100,000 lien filed against their home, or $1 million lien. I'm not sure what the experience has been here in Minnesota, but it has been pretty devastating in some parts of the United States. And I think we did have a bill that passed a few years ago that was drawing attention to it. And if I recall, we were trying to do something so that the clerks didn't, because evidently the lien was in effect as soon as the clerk accepted the paper. And we were trying to make sure that that didn't happen. And I don't know exactly what we finally did, but I have to say I applaud you for bringing this up because it has been a very serious issue in some parts of the United States, and it's come to Minnesota too.
Thank you, Senator Carlson. Senator Anderson.
Thank you, Mr. Chair. Senator Matthews, are there penalties in here?
Senator Matthews.
Ms. Freeman, Mr. Chair.
So there are not penalties in this bill specifically, but there are penalties, and now I'm just, need to look and see the section. There are penalties related to making a fraudulent filing in general with our office. And so, or, with the state of Minnesota. And so that's what would be reflected back onto.
So, Mr. Chair, Ms. Freeman, there's
Senator
nothing in
Anderson.
here specifically to say that there's a penalty for such and such of a filing of a wrong claim or anything like that. There's nothing in here, in this bill.
Correct, yes, I think, excuse me.
No,
Sorry,
please go
Chair.
ahead.
Thank you, Senator. So there are not penalties specifically in this bill. In talking with the one issue that came up as we were talking about the bill with other stakeholders and the County Attorneys Association in particular was there are laws on the books right now. They're currently hard to enforce relating to this particular action. And so what we took with this bill is a way to alleviate the filing for the citizen that's being, filed against and having the lien put against them. I can.
Senator Anderson.
One more.
Thank you. Any further questions, comments? Senator Matthews.
Thank you, Mr. Chair. I appreciate the committee's consideration of the bill, and thank you to the Secretary of State's office for helping bring this to our attention. So with that, Mr. Chair, I'd move that Senate File 3920 be recommended to pass and referred to general orders.
On Senator Matthews' motion, all those in favor say aye.
Aye.
All opposed? Motion passes. Where did my check go here? Impose a call.
Yeah.
All right, members, there's a bill and an amendment being passed out, Senate File 4209. I'm hoping Senator Housley is on the call.
Yes, Mr. Chair, I'm here.
Mr.
All
Chair,
right, we'll get you highlighted. Senator Limmer.
isn't there an old rule of the civil law that authors have to be present to present their bills, no matter what the time is?
Or the COVID era or not?
I'm not hearing anything from Senator Housley on that.
Mr.
Senator
Chairman,
Ladd?
Senator Latz.
does Senator Housley have the ability to opt out of a presence requirement and appear only digitally?
Yes, because she's phoned a friend to move her amendment and bill for her.
We are at that time of the evening, ladies and gentlemen.
I'm going to say as little as possible so we can get out of here.
Senator Housley to Senate File 4209.
Thank you, Mr. Chair. I do have the A2 amendment, so if someone could move that for me.
Mr.
Senator
Chair, I'll
Bigham.
move the A2 amendment for Senator Houses.
Senator Bigham offers the A2 amendment. It is not an author's amendment, so Senator Housley, would you be able to help explain your amendment?
Yes, Mr. Chair, and I might need the help of council also because this is recent. But it creates another section for recommendation and reports to the governor. specific reports and general reports and reports that all of the stakeholders had input on, and they're all okay with this language in the amendment.
Ms. Primo.
Mr. Chair and members, in addition to the language covered by Senator Housley, the amendment also makes a few data changes to Section 1 of the underlying bill. It provides that once an investigation is inactive, that data is private, and when it is an open and active investigation, that data is confidential.
Thank you, Ms. Primo. Any discussion to the A2 amendment? Seeing none, all those in favor say aye. Aye. Opposed, no. The amendment is adopted. Senator Housley, do you have any more for your bill?
Yes, I'll be quick, Mr. Chair. Senate File 4209 is to create an ombudsperson office for foster children. I'm speaking to the critically important issue of ensuring that the children in our state's foster care are protected and served just as well as children in our own homes. This bill would create an ombudsperson office and aims to provide oversight for the systems that are tasked with protecting children from harm, and to create a vehicle that can adequately track the issues affecting these young people in Minnesota. This is needed because fosters don't have a resource or avenue for intervention when they are being abused or neglected at the hands of our own child protection systems. And as it stands, there's no organizations or entities that track complaints or common concerns that arise for foster children. So without this data, we are left powerless to affect meaningful changes in our existing structures. So by establishing the Ombudsperson Office for Fosters, we're creating an organizational structure that will create positive change, allow for more capacity to do independent investigations and track areas where significant intervention is needed. Navigating the foster care system alone is a challenging task in itself. So without appropriate tools and advocates, we'll continue to fail these children and continue to repeat this all too common cycle we see in our communities. So your committee has parts of Section 1 and all of Section 1 and parts of Section 4. So with me, I think he stayed. Wong Murphy, my testifier. So I think he is still there.
Must be Mr. Murphy.
Yes.
Welcome to the committee. Thank you so much for your patience with the late hour. If you would state your name for the record and then please begin.
Wong Murphy. Good evening, and thank you all for staying so late and hearing this bill today. I will try to break a land speed record by getting through my testimony as quickly as possible. So my name is Wong. I'm the founder and ED of a nonprofit called Foster Advocates, and we work with young people who have experienced foster care. So when families are not good places for children to be, the government is the one that steps in and makes sure that they are okay. But who intervenes when it is the government that is causing the harm? And so really, this just begs a basic question. Who is watching the watchers? Currently, no one. Children entrusted to our care must face the challenges of life on their own after aging out. They shouldn't have to face the foster care system alone as well, with no one to call for help. And it doesn't have to be this way. We can do better for our young people. We must do better. Creating more opportunity for the Ombuds Office to lead meaningful change and improve systemic issues plaguing the child welfare system in the state of Minnesota. This will have a trickle-down effect for the state's child welfare system by anticipating and fixing issues that otherwise may lead to endangerment of a child, and also it will curb any potential lawsuits by former or current foster youth who have been harmed. These are our children. They became ours when we separated them from their families. We owe them a duty of care just as strongly as the children in our own homes. The fundamental truth is, children are children, and they should be afforded the right, and it should have an expectation that adults will take care of them. But I've repeatedly seen at the personal level, and now at the systemic level, that this is not happening. It is my sincerest hope that all of you, those of you who are in power and in a position to change this, reflect deeply on our moral responsibility and the cost of our continued indifference. So please support the creation of an Office of the Ombudsperson for Fosters. Thank you. I would also just note that there is bipartisan support in both chambers, and that there is a effort to also move this office from the governor's purview to its own separate office as well. And so that will be something that will be addressed later on. But I wanted to address that here.
Thank you, Mr. Murphy. Mr. Ealing, were you planning to testify as well? Welcome to the committee. If you'd identify yourself for the record and then please begin.
Thank you, Mr. Chairman. Matt Ealing, Minnesota Coalition on Government Information. I'm merely here to say that I worked with Mr. Murphy on the data provisions and am available for questions. So that's my only purpose to be here, Mr. Chairman.
All right, thank you. Senator Bigham.
Thank you, Mr. Chair. I really like this idea. I've received a few calls through the years about siblings, for example, that are both in foster care that aren't being allowed to see each other as scheduled and as required by a court order. And you kind of, other than calling a social worker, which you can't because all that's private data, right? You don't really have a place to go. And so I really think when you have incidences like that, when kids are aging out and they have a sibling who hasn't yet, I think this is a great idea. And I also like the idea of having it be on its own like we have our other ombudsmen. So I like the idea.
Thank you, Senator Bigham. Any other discussion or questions from members? Senator Anderson.
Senator Housley, I see that you're, and this probably is not our bailiwick, but your appropriation for this office on 5.20 is $650,000. I'm just, is that just for the ombudsperson, or is that for more than that?
Mr. Chair and Senator Anderson, it's for more than that. There's quite a few staff that will be hired, and maybe Mr. Murphy can follow up with that.
Mr. Murphy.
Yes, the uses for that will be the foster care board that will be appointed to make sure that foster youth also have a say in the office's processes, including several professional staff appointments. And the vision for this is that there will be likely be several staff helping this ombuds office, including at least one attorney and likely a social worker.
Senator Anderson.
One attorney, did you say?
Mr. Murphy.
At least one. There will likely be about 5 FTE staff, 1 admin and 2 investigators, and 1 legal counsel. But that's something that should be shaped by the ombudsperson.
Senator Anderson.
Sir, could you tell me how many people are in the foster care system here in the state of Minnesota?
Mr. Murphy.
13,000 currently.
Senator Anderson.
Mr. Chair, sir, is that 18 below, 18 as far as the age of these individuals?
Mr. Murphy.
The large majority are under 18, but there are about 370 that are in extended foster care, so 18 to 21.
Okay.
Senator Anderson.
Thank you.
Senator Limmer.
Thank you, Mr. Chair. Staff pointed out to me there might be a word change that might be necessary. Bring your attention to page 5, line 14. We try to not tell the third branch of government what to do. We suggest, and on lines 514, I would move that we change the word from must, strike the word must and insert may.
Senator Limmer moves an oral amendment. Ms. Primo.
Mr. Chair and members, just to bring it to the committee's attention, and then Senator Limmer can proceed with his amendment. So that phrasing, it's this district courts and the administrative agencies must. So by changing must to may at that point, you're also changing the mandate to the administrative agencies. So an alternative option, if Senator Limmer is interested, would be to insert may after courts. So it's the district courts may and the administrative agencies must.
I'll
Senator
incorporate
Limmer.
that into my oral amendment, Mr. Chair.
Senator Limmer moves the oral amendment and incorporates as read by council. Any discussion to that oral amendment? Seeing none, all those in favor say aye.
Aye.
Opposed, say no. The amendment is adopted. Any further discussion? Senator Housley, any final comments?
Yes, thank you, Mr. Chair. First, I want to thank you so much for hearing this bill and getting it in. It means a lot to us and those 13,000 kids, and to Mr. Murphy. Thank you so much for hearing that. I appreciate it, and thank you for getting this through quickly. You guys got to get out fast because the wild game is almost over and you want to miss that traffic. They're tied 3-3. Not that I've been watching it during your committee. I've been watching your whole committee since 5:30. But thank you, Mr. Chair and members. This is a good bill, and I appreciate it.
What did we talk about last half hour?
I don't know, but you can ask Senator Latz. I just sent him a text and told him he might want to leave early before my bill comes up.
Senator.
I saw it all.
Oh, Mr. Chairman,
Senator Latz.
this is a good bill. I think we should vote for it.
I thought you were going to move to reconsider.
Senator Limmer moves Senate File 4209 as amended be recommended to pass and referred to the State Government Committee. On that motion, all in favor say aye. Aye. Opposed say no. Motion prevails. Thank you, Senator Housley.
Thank you, Mr. Chair and members.
Members, briefly, there may be a chance we do an informational hearing down the road yet this session, but this is likely our last meeting for passing legislation here. And from the bottom of my heart, I want to say thank you to each and every one of you for this session the last few years. We have some differing viewpoints, and we have debated them vigorously and with respect and decorum that this institution demands of us and our constituents demand of us. And so for that, I sincerely thank each and every one of you and appreciate the time that we've had to work together. And Senator Bigham, you have a very memorable last hurrah from your time here on the civil law.
Mr. Chair.
But that's judiciary. This is civil law.
Thank you, Mr. Chair.
Senator Bigham.
One, thank you. You've been very responsive and very good with communication, and I appreciate that. That's always good for a chair and lead relationship. I also want to thank all of our staff, partisan and nonpartisan, for what they do. They are saints for keeping us straight, so and keeping us organized. So really appreciate that and appreciate the friendships and the long-lasting memory that I now have as my final experience in the committee. So thank you.
Thank you for the reminder. I too wanted to thank our staff, all the way down to our pages. Thank you for the work that you do. I was a page years ago in this body once, and I know what you do with the details of committee and the hours that you keep here when we sit here and talk on and on and on and on and on. So, members, thank you for that. It's been a wonderful experience with you all. And with that, this committee stands adjourned.